He's out now.
Okay, Discover Bank versus Donna Balintz, 2403981. Ms. Balintz, you have to start your video and state your name, please.
Donna Balintz.
Good morning, counsel. Good morning. How are you?
Thank you. Good morning, Your Honor. Daniel Best, P58501, on behalf of plaintiff, which is now Capital One successor by merger to Discover Bank.
Right. So did you two talk and resolve this?
We talked. We have not resolved that if Ms. Balink is still working with a debt settlement company. I am not showing that we've received any offers or anything from them. And I, again, told her, and not again told her, that came out completely wrong. In our discussions, I advised that, you know, if the court grants the summary disposition and judgment gets entered, she's really on the clock at that point in time, and she needs to get her debt settlement company motivated to get a hold of us.
Well, I'm ready to go forward with the motion. I'm sorry, ma'am. There's nothing I can do. Go ahead, counsel.
Thank you, Your Honor. This is an action on a credit card account. Originally, it's Discover. Since the initiation of this action, Discover merged with Capital One, and they have continued under the Capital One name. But the statement, there was really no factual issues. Defendant acknowledged in her answer that she had the account. She did identify a balance that existed at the time that she engaged the debt settlement company. The statements we have attached show the full balance owed of $9,152.53. We're also asking for court costs of $249.50 for a total requested judgment of $9,402.03. We're also asking for interest pursuant to MCL 600.6013, subsection 7, at the contractual maximum rate of 13% per annum from the date of the filing of the judgment.
Ma'am, anything you would like to say?
I'd just like to say that I'm doing everything that I can with this company that they told me they've done their part, and apparently they haven't. I just retired and I'm receiving Social Security at this point. So that's, I mean, I'm not sure what to do, but I'm going to get a hold of them again.
Yeah, the problem is these out-of-state companies, and they're not licensed to practice law. And I don't know what else to tell you. I feel bad for you, but there's nothing I can do. I'm a grant plaintiff's motion for summary disposition. There's no genuine issue. As to any material fact, judgment will enter in the amount of $9,402.03, including the court costs of $249.50. Maybe you can work out a payment plan with Mr. Best. That's a reasonable one. Nobody wants you to go bankrupt here. And but Mr. Best is going to send that judgment to me for my signature, and I'm going to sign it, okay? If you want, you can file a motion for installment payments, and I'll set up a payment plan that's reasonable for you, okay?
Okay, I'm not sure how I would do that, but
well, you can come up to the courthouse here and file a motion for installment payments.
Okay.
How much can you afford to pay per month, ma'am?
Well, as you know, I'm on a budget. I do get a small pension from school bus driving and then my Social Security. So I mean, it's not a whole lot. I mean, I could, you know, it sounds pretty chintzy, I know, but like 25 to 50 bucks a month would probably be the most that I could afford, because I still have a mortgage payment, obviously, with other bills that you have to have, you know, pay at this point. But I'm hoping, I really am hoping that I can get a hold of this company and we can work something out within a certain period of time that they're going to give me.
Okay, well, I'm going to go ahead and grant their motion. If you decide you want to file a motion for installment payments, you can do so, okay?
All right, thanks.
I sincerely wish you well. Good luck to you, ma'am.
Thank you.
Thanks, Mr. Best.
Have a good day, everyone.
Two. Paul Stano versus DBA Charm Real Estate versus Brian B. Stone, 2502300. Good morning, counsel. Your appearance?
Yes, good morning, Your Honor. Mark Kiaz on behalf of the Charm Real Estate LLC.
Yeah, we just adjourned this for the issue of money judgment, and I'm going to conclude you're not entitled to one. I'm going to go ahead and I'm sorry I had to come back. I really am. I just wanted to double check something. They've changed these rules so many times since COVID that with the second mailing, I wasn't sure if they were going to consider that to be personal jurisdiction or not. But at any rate, can you just prepare an order that says the issue of money judgment is preserved and send it over to me? You can refer to the prior judgment, possession judgment having been entered on such and such a date, hearing having taken place as to whether or not the plaintiff is entitled to a money judgment. And it is hereby ordered that the plaintiff is not entitled to a money judgment at this time, but the issue of money judgment is preserved. Okay, if you could just send me that, I'd appreciate it. Sorry again for having you come here.
No problem, Your Honor. Again, yeah, I looked. I didn't see anything that changed, the requirement of personal service. But a quick question for you. We have not received a copy of the possession judgment, and I looked online. It didn't show that it had been entered.
You know what? I was on vacation last week. And I will get to that today. My apologies.
No, I appreciate that very much, Your Honor. And again, thanks for this hearing. Thanks for the information. You have a great day.
You too. Thanks a lot. Bridgewood versus Devin Vanner, 2502429.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Good morning, Mr. Landman. How are you? Jennifer, is Devin Vanner here? I don't see him.
No, Your Honor.
All right. So, Mr. Landman, you can go ahead and take a default. There was second mailing here.
Thank you, Your Honor. Plaintiff does respectfully move for the entry of a default judgment for possession only. Based on my client's books and records, the rent to retain is $1,216. Costs are $191.04 for a total of $1,407.04. And the proposed possession judgment provides for a writ date of July 17th.
How much are the late fees?
Your Honor, the late fees, according to the ledger, are $50.
Okay, good enough. You submit your judgment. The amount to be paid to save it is $1407.04. And the writ date in this case will be July the 17th.
Your Honor, let me amend that. It's $50 a month for May and June.
No, that's fine.
Okay.
I do up to 70 now if the contract so provides, but.
Understood.
Okay, so let's go on to Fountain West versus Taj Jackson, 2502494. There you go. You have to take your hoodie off. Wait a minute now, sir. At the side of a house. Now you got to get that idiot that straightened away for me here, okay? All right. Now wait a minute. Wait. You got to take your hoodie off.
Oh, my bad.
Okay, now wait a second. Why are you walking around? Tell me why you're walking around.
Just so I could hear you. I was outside and I couldn't really hear you.
All right, now listen. I got to see your face. I don't want to see a moving camera, okay? I get dizzy, all right? Just stay right there. And Mr. Landman, your appearance.
For the record, Daniel Landman, appearing on behalf of Bridgewood and Fountain West.
Did you listen to and understand the rights on the video, Mr. Jackson?
Yeah.
Do you wish to speak to an attorney?
No.
Do you intend to apply for funding?
No. I was waiting on my unemployment. I have I have 20 weeks of it left, but I only claimed 10 of it. And I have actually a court date for them later on today for them to release my money so I can pay my rent. That's the reason why I haven't paid it. I've talked to their leasing lady or whatever, like whatever she is that she works there, the groundskeeping or whatever she is. I showed her the letter and everything, and she said as long as I just show up to court, I talk to you guys, and then.
Okay, slow down, Mr. Landman. What's the total balance due right now?
Your Honor, including July's rent, the balance is $3,096. Costs are $181.13 for a total of $3277.13. Of that amount, there's a $50 late fee for May and a $50 late fee for June.
When could you pay that, Mr. Jackson?
They should release my money within the next 2 or 3 days, the unemployment people. But I have to talk to them today. I have a court appointment with them at 2:30 over the phone. So they would be letting me know when they release it, and they release it.
I know, but you're not going to get 3277.13, are you? Why am I seeing the wall again or the ceiling? Come on.
I can't really hear you. The phone's not that loud. I'm sorry.
They're not going to give you 3277.13, are they?
Yes, they are. They owe me more than that. They owe me for 10 weeks of unemployment.
Okay. What do you want to do, Mr. Landman?
Your Honor, I would prefer certainly to enter a judgment today if the court is so inclined and concludes that there are no triable issues. If the court wants to extend the writ date by a week to allow an extra week for this unemployment to come in, obviously it has the discretion to do so because it could adjourn this case for a second hearing. I'm not confident that Mr. Jackson is going to get his unemployment within the next 2 or 3 days, if at all. I mean, I don't know what the reason would have been for withholding it in the first place.
All right. Mr. Jackson, you agree that you owe that amount? Sir, do you agree that you owe that amount?
What'd you say? It had froze. I'm sorry.
Do you agree that you owe that amount?
Yes.
Okay. Here's what I'm going to do. I'm going to enter a judgment after hearing. There is no tribal issue. I'm going to grant judgment in the amount of $3,277.13 for possession only. The writ date in this case will be July the 21st. So I'm going to give you a few extra days there, but you have to have that money paid or vacate on or before July 21st, which is 2 weeks from today. Okay?
Okay.
All right. And that'll be after hearing. Any questions?
Nope.
Wish you well, Mr. Jackson. Good luck to you, sir.
All right. Thank you so much.
First is Elizabeth Preston and Jamie Preston, 2502511.
Daniel Landman appearing on behalf of the plaintiff.
I do not have the Prestons present.
Okay. You paid for a second mailing. You can take a default.
Thank you, Your Honor. Based upon my client's books and records, there is a total rent to retain of $2,798. Of that amount, there's one $50 late fee. Court costs are $223.11. So the grand total is $3,021.11. Plaintiff moves for the entry of default judgment for possession only with a writ date of July 17th.
Defendants failed to appear. Default judgment will enter. The writ date will be July the 17th. The amount to be paid to save it is $3,021.11. Do you have any more, Mr. Landman?
That is it, Your Honor. Thank you and have a wonderful day.
You too. Thanks a lot. All right. Let's see here. I'll do the 9 o'clocks. Brownstown Square. Is anybody here from Mr. Cox's office? There we go. Brownstown Square versus Luis Morales. 2502327.
Good morning, Your Honor. Attorney Elizabeth Ellison, P82098 for the plaintiff.
Good morning. I have an interpreter here. Your name, please?
Shalonda Heisley, Heisley.
And the first name, can you spell your first name?
Shalonda, Shalonda.
All right. Good morning. And you are Certified interpreter in Spanish?
I received my court qualification in 2019.
Okay, raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the defendant?
Yes, Your Honor.
And all parties, I should say.
Yes, Your Honor.
All right. So let's start with this. Sir, tell me your name, please.
Luis Alejandro Morales.
Did you listen to and understand the rights in the video? You couldn't have because you didn't understand English, right?
No.
Oh,
No.
so I'm going to go ahead.
I only understood a little bit.
I'm going to go ahead and give you your rights verbally, okay? All right, so we're going to go slow. You have the right to a lawyer. You have the right to proper venue, meaning that this is the place where the case should be filed. You have the right to a jury trial. You have the right to apply for funding with a variety of different agencies. The Department of Health and Human Services, the local coordinated entry agency, housing assessment and resource agency, the Federal Help for Homeless Program, and they may be able to assist you with payment of some or all of the rent due. You don't need a judgment to apply for assistance. And there's also the possibility of a conditional dismissal if all parties agree, meaning that you could agree with the plaintiff attorney to have the case dismissed, subject to certain conditions being performed by you. In this case, to pay your rent at whatever increment the two of you agree upon. Do you understand all those rights?
Yes.
Would you like to speak to a lawyer?
¿Cómo te sí entiendo lo que está pasando? Tengo que trabajar. Y vengo con la intención de llegar a un acuerdo, o sea, de que me permitieran esta semana para que pague totalmente.
Dentro de 3 semanas?
Sí, o sea, para, o sea.
Well, I'm not really sure what I would need to for that because my intention is to come here to make sure I can make the payment. I'm hoping to be able to pay it in 3 weeks.
All right. Ms. Ellison, what is the total amount due? Just give me the total, no breakdown.
$3,364.79.
$3,364.79 is the balance.
Correct, Your Honor.
Do you agree that you owe that amount?
Yes.
When can you pay all of that?
If you allow, like 3 weeks.
Your Honor, could we just do a consent with the writ date 7/31, just because I know it needs an interpreter. So if we could just do it and have it paid by the end of the month.
All right.
He's asking, is this for the payment date, the 31st of July?
So you're willing to give them all the way until that date to pay all of it?
Yes, Your Honor, for the circumstance.
I understand.
Yes.
So I'm going to give them a judgment after hearing that indicates that you owe $3,364.79. By the way, you're not charging any more than $70 in late fees, correct?
Your Honor, they charged $75. I credited $10 for May and June. There is no late fee as added as of July right now, Your Honor.
Okay, but you're only charging $70 for any late months, right?
Correct. I adjusted it and I'll tell my client to adjust it accordingly.
So, sir, you have to pay this amount by July 31, or you have to vacate. If you do not pay up and do not vacate, I'm going to sign an order of eviction and you will be evicted by the court officer. Do you understand that?
Yes.
So you have to pay all that by July 31. I want to be clear.
Yes.
Do you understand that?
Yes.
Do you have any questions?
Yes.
So
So after I made this payment, let's say I make this payment, I don't have to come back that date, I don't have to come back anymore if I make this payment?
You don't have to come back on July 31 either. You just have to either pay up by that date or get out of the property by that date. If you don't do either one of those things, then you're going to be evicted. I'm not setting a court date for July 31. Do you understand all that?
Yes.
Any questions at all?
no.
Okay.
Your Honor, just if we could just tell him, remind him that his August rent will then be due on August the 1st.
Yeah, you're gonna have to pay your August rent on August, in August. Okay? You understand that?
Yes.
Okay. Good luck. Thank you so much for coming. Ms. Heisley, is it?
Yes, Your Honor.
Thank you very much. I appreciate your help.
Okay, have a good day.
Good luck to you, sir. Thank you. And you can submit your order on that one. Thanks.
Your Honor.
All right, Golden Management versus Audrey Winn, 2502355.
Good morning, Your Honor. Stephen Debates, P81248 on behalf of the plaintiff.
I wrote down all the figures. Your name? I wrote down all the figures. I wrote rip date, and then I must have gone back and just adjourned it. Is that what happened?
Yeah, there was, the defendant claimed they made some payments that were not reflected on the original amount. And that did turn out to be true, Your Honor. So we do have updated amounts.
Okay, give me updated amounts now.
So as of today, we have rent owing of $2,488. We have $125 in late fees. We have $225.43 in costs for a total of $2,838.43.
How much are your late fees that you're charging?
It's 25 if not received before the 7th, and then another 25 not by the 16th. So a total of 50 if they haven't paid by the 16th.
Okay, so they're capped. I capped them at $70. Ma'am, do you agree that you owe that amount?
Yes.
2,838.43.
Yes.
Can you pay that amount?
I'm actually at the moment currently, I've already made 2 payments of $350 to Tracy, my landlord. And I also wrote her a written note saying that if I pay her $350 or more, because I am getting a raise, a $5 raise at my job this week. So I could start paying more than just $350 weekly. I could have it paid by the end of August, no later. That's with August and July rent added in as well.
You understand what she's asking?
For a payment plan, Your Honor.
$350 a week.
But it will be raised because I will be.
Well, you guys want to go into a breakout room and talk about this one?
Yeah, I think we can do that, Your Honor.
Yeah, let's do that. I'm gonna take your next Golden Management case. Is that the only other one you have?
That is, I did have a third one, but we submitted a CD on the 3rd. I just wanted to make sure that was received by the court.
Yeah, we don't have it on the docket any longer.
Okay, thank you very much.
So, ma'am, my courthouse is going to take you to a computer where you can talk to Mr. Debates about this case. I'm going to take one other case with him before you go there, okay? I mean, you can go in the room now, but I'm just saying it might be a couple minutes. Golden Management versus Reno Wesley, 2502356. Reno Wesley.
Judge Chronic, Your Honor, on behalf of Mr. Wesley.
Good morning. Mr. Wesley, start your video, state your name.
Yes, sir. My name is Reno Wesley. Good morning, Your Honor.
Good morning. And counsel, your appearance again?
Thank you, Your Honor. Stephen Debates, P81248 on behalf of the plaintiff.
Okay, so what did we do here? He wanted to speak with you. He applied for funding. Did you submit your proof to the court within 5 business days that you had applied for funding?
It has been filed with the court, Your Honor.
Has he heard anything on that?
It's still pending.
Okay. All right, so Mr. Debates, I think he's entitled to another adjournment. So I'm going to go ahead and adjourn it.
Yep, and that's absolutely understandable, Your Honor. He is entitled to that. I'm not aware of your procedure, Your Honor. Is it appropriate, or would you entertain a request for escrow at this moment?
I mean,
Your Honor, he's applying for rental assistance.
yeah, I mean,
that's fine, Your Honor.
Let's adjourn it. I'm just going to adjourn it at this point. I don't see, yeah, I'm just going to adjourn it to July the 21st. At what time, John?
We can do 8:30, Your Honor.
And sir, you have not heard anything from the funding agency yet, correct?
Not as of yet, Your Honor.
Okay, so we'll adjourn this July 21 at 8:30, but if you don't have the money then, I'm going to give them a judgment. You're going to have 10 days to pay up or vacate. Counsel, why don't you give them the total balance owed as of this moment?
As of this morning, Your Honor, we have rent owed in the amount of $2,000.
I don't need a breakdown, just a total.
Total $2,708.43.
So whatever you get or don't get, you're going to have to pay that, sir. All right?
Okay.
So if you don't have that paid by then, I'm going to give them a judgment. You're going to have till the 31st to pay. All right?
All right.
Best of luck. We'll see you in a couple of weeks. Anything else, Ms. Prucknick?
No, Your Honor. Thank you.
Thank you very much. Good luck, sir.
All right.
Thanks,
Your Honor.
Counsel. I'm going to recall your other one when I see you pop back in, okay?
Thank you, Your Honor.
All right. Epic versus Branzy Blaz and Jerry Taylor, 250-2385. Blaz and Taylor.
Good morning, Your Honor. Attorney Elizabeth Ellison, P8 for the plaintiff.
Good morning, Your Honor. Brandy Blaz and Jerry Taylor.
Where's Mr. Taylor?
He's at work, Your Honor.
He's got to show up. I'm going to have to.
Yeah.
I
believe he was trying to get on, but I'm not sure if he had any luck.
All right, let's do this. Ms. Ellison, why don't you tell me what is owed?
Your Honor, rent to retain is $4,425.05. Court costs of $223.56. The total being $4,648.61. Late fees are only $50 a month, Your Honor. So there's a $50 late fee included in that number for June and July.
Ma'am, do you have that amount
Yes.
to pay?
I am here right now at Epic in my car. I have half of it to pay right now, and I will have the rest by Friday.
Okay. So what I'm going to do, though, I'm going to give her a judgment. Okay. You
That's
agree
fine.
that you owe that amount, correct?
Yes, correct.
I'm going to give her
Yes.
a judgment after hearing versus you, Brandy Blaz, and by default judgment versus Taylor.
Okay.
And I'm going to give you a writ date of July the 21st, July the 17th. I'll give you until the 18th, okay? So
Okay.
you have to pay all of it by the 18th or vacate. If you don't, then I'm going to enter an order of eviction and you'll be evicted, okay?
Okay, Your Honor. Thank you.
Do you have any questions for me?
Nope, none at all. It'll be paid.
464862, was it? Or 61?
4861, Your Honor.
And then the writ date is July the 18th. Okay. Good luck to you,
Correct.
ma'am.
Thank you so much. Have a good day.
You too.
Bye-bye.
Do you have another one?
Your Honor, my other two were dismissals. So as long as they're off the record, then I'm good to go.
They are.
Okay. Have a good day. Thank
You as
you.
well. Thank you.
South Point versus Tierra Hill, 2502523.
Your Honor, we just made a call to plaintiff's office. I don't have counsel yet.
Riverside Townhomes versus Tamia Palmer and Jason Johnson, 2502530.
Your Honor, it's the same attorney.
Well, did anybody answer there?
No, we got a voicemail. I'm calling again right now.
Call again. Otherwise, Give me the other 930s, will you?
I don't have plaintiff's attorney on the 930s yet.
Yeah, try again, will you please, Jennifer?
I am right now, Judge, and it goes right to voicemail. I'm going to try just waiting through.
Does any lawyer have a case ready where a defendant's here that they know of?
No.
You gotta go out.
All right, well, I don't know what to say.
We have it in custody at Brownstown.
Call, yeah.
This is 33rd. You guys have it in custody. Can you get ready to put judgment now?
We're ready right now, Tom.
All right, thanks. That's it.
I'm just looking to see if I can do
I just called Brownstown.
Do I have any management here for from South Point or Riverside or Williamsburg or Tanglewood?
Oh,
On the iPhone, can I get your name, please?
Ivan Manzo.
Nope, sir, I already got you. Gentleman with the gray shirt and glasses, can I get your name, please?
Bill Springer. Is he hearing me now?
Yep, I heard you. Thank you very much. I'm going to
Okay.
change your name.
Yeah, you have to identify yourself with that in the future, okay, sir? With your name on your phone when you're zooming in.
Okay, I apologize about that.
It's all right. I'm not going to make these people wait much longer, Jen. So let me know when you call the second time.
Okay, I'm calling right now. I've got it on speaker.
They're not yet.
Judge, when I press it, it just goes to a voicemail.
All right. Well, I'll just make a note. We called twice. I don't think it's fair to keep them here. I'm gonna go ahead
I
and
have also tried emailing the person that handles their proof of service and sends them to me. I sent her an email as well.
South Point versus Tierra Hill, 2502523. Is Tierra Hill here?
No, Your Honor.
Plaintiff attorney failed to appear. Defendant failed to appear. Adjourn 1 week. You can pick the time. What time do you want to do? I guess we should put it in now since
11. We've got a lot next week.
July 14th at 11. South Point versus
Mr. Landau?
What's that?
I've got Mr. Landau on the phone.
We'll get him on here.
He's logging in right now, Your Honor.
Look, I'm going to get off the bench here. I'll be back in a couple of minutes. Everybody stay seated. Is Brownstown out there?
They're not.
Good morning.
Good morning.
All right, we're going to go start over again, go back on record. South Point versus Tierra Hill, 2502523. Mr. Landau, your appearance.
Good morning, Your Honor. Mark Landau on behalf of the plaintiff.
So I called this case, indicated I was going to adjourn it. That's when we were on our second phone call. So she's not here. I'll go ahead and if you want to take in a default here, I'm glad to do that.
Yes, Your Honor. We are seeking the entry of a default judgment of possession for non-payment of rent. The rent owing, not including late fees, is $2,875.76. Late fees are $225 total, comprised of $75 per month for 3 months.
I only give, didn't I say 70, Jennifer, or did I say 75? I think I said 70,
70.
didn't I?
Yes, Your Honor.
Yeah, so you got to lower those to 210 from 225. And then what do you have court cost wise?
$179 in court costs. Total is going to be $3,264.76.
And that's backing out the $5, the $15 in late fees, right?
Correct.
Okay. Let me just.
Judge, I think you need to increase it by $5. Make it easy on me.
326476. Writ date will be July the 17th. Make sure you send that over this morning, though, will you please?
Will do.
I'm going to take, I forgot about Golden Management. Mr. Debates was here. Then I'm going to come back and take the rest of yours. It'll only take a minute. Golden Management versus Audrey Winn, 2502355. Counsel, Mr. Debates, your appearance.
Thank you, Your Honor. Stephen Debates, P81248 on behalf of the plaintiff.
Ma'am, your name?
Audrey Winn.
So everybody agreed that 2838.43 was the amount to be paid. And did you guys work out a payment plan?
We did, Your Honor. So,
all right.
Ms. Winn has agreed to pay $350 per week until he fully caught up. She must be fully caught up by the end of August. That includes the remainder of July's rent and August's rent.
All right, defendant to pay $350 per week until entire balance paid. All money to be paid, including August rent, which is what again, counsel?
$800.
By August 31. Do you agree to those terms?
Yes.
So total amount owed as of now is 2838.43. So essentially you've got to pay 3638.43 by August 31st. All of it has to be paid. A minimum of $350 per week. Do you understand that?
Yes.
Do you agree to those terms?
Yes, I do.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that? All right, counsel, submit your judgment today, please. Does he have your permission to sign your name to that proposed consent judgment?
Yeah.
Okay, so she's given you that permission. I'll ask you to send that over today, if you would, please.
Thank you very much, Your Honor.
Have a good day, ma'am. Any other questions? I can't hear you.
No.
All right, I wish you well. Good luck. Thank you. Brownstown Square versus Juliana Jones, 2502524. You ready on yours, Mr. Mesmore?
Yes, Your Honor.
So you can tell my court officer when he comes in to get the prisoner out. Is Juliana Jones here? I don't believe she's here, Mr. Landau. Your appearance?
Mark Lando on behalf of the plaintiff. We are seeking the entry of a default judgment of possession for non-payment of rent. She owes $1,016.08 in rent, and all her late fees are paid. So it's just the $1,016.08 in rent, $179 in costs. Total is $1,195.08.
Okay, so no late fees.
Correct.
All right, defendant failed to appear. Default judgment's entered. Writ date will be the 17th day of July. 25, 1195.08 is the amount to be paid to save it. South Point versus Ivan Manzo, 2502525. Mr. Manzo, your name, sir?
Hello, sir.
Your name?
Ivan Manzo Cervantes.
Your appearance, Mr. Lando?
Mark Lando for the plaintiff.
Did you listen to and understand the rights?
Yes.
You wish to speak to a lawyer?
No.
Do you intend to apply for funding?
Yes.
You are going to apply?
Yes.
What's the total balance owed? I don't need any breakdown now.
$2,685.20.
All right. That entitles you to a two-week adjournment. I'm going to adjourn this to July the 21st, but you have to provide proof. You have to provide proof that you've made application for funding to the court within 5 days. Do you understand that?
Yes. Can I?
One second. Jennifer, July 21, is that at what time?
10 a.m., Your Honor.
At 10 a.m. What is your question, sir?
I wanted to ask if I could set up a payment plan.
Well, you just got done telling me you're applying for funding, right?
I'm sorry. No, not funding for housing assistance.
You're applying for assistance or you're not?
No, Your Honor.
You're not applying for funding. My mistake. Okay. So you still owe $22685.20.
Yes.
What are you looking to do? When can you pay the total balance here?
The end of July.
How about, Mr. Landau, if you put in a judgment for $22685.20, this would be by consent, or we could do it after hearing. And then I'll set a certain percent or amount that he has to pay by the 17th. Is that fair?
That's fair.
You want to do it by way of a consent judgment? Do you agree to that, Mr. Manzo?
Yes, I do.
So you agree that you owe $22685.20?
Yes, I do.
And I'm proposing that you have to pay at least $1,650 by July 17th. And if you do, you have to pay the balance by the 31st. Can you do that?
Yes, I can.
And you're sure you can pay the $1,650 by July 17th?
By July 17th.
That's by next Thursday.
Next Thursday. I'm not 100% confident, but
can you pay that by the 21st?
Can I do it until the 22nd, the Friday?
The 22nd is not a Friday. That would be a Tuesday, right?
Oh, can I have until that Friday?
What's that, the 25th?
Yes.
Any problem with that, Mr. Landau?
Can we get a smaller payment in by the
17th? How much can you pay by the 17th?
By the 17th? I could pay 1,000.
All right, you sure?
Yeah.
All right, so you agree to that, Mr. Landau?
Yes, Your Honor.
All right, so sir, this is going to go down as a consent judgment. He's going to prepare this. Does he have your permission to sign your name to a judgment that says you owe 268,520?
Yes.
With a writ date of July the 17th, but if you pay 1,000 by July 17th, the writ date will be extended until July 31.
Yes.
You agree to those terms?
Yes, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes, sir.
Any questions?
No.
All right, so he's going to sign your name as you agreed upon. He'll send it over. Just make sure you get him that $1,000 by July the 17th, right? Is that what we said?
Yes.
Yes, yes.
Judge,
Okay.
I made one really small mistake. It was not 2685.20. It was 2685.70. Add another 50 cents. I apologize.
Okay, so you agree to that, sir?
Yes.
All right, so that's what we'll do. He'll sign your name, 2685.70, pay 1,000 by July 17th, balance no later than the 31st. Otherwise, you have to move out, okay?
Okay.
Good luck to you, sir. Thank you. Ryan Mesmore.
Thank you.
South Point versus Ryan Mesmore, 250-2526. Your name, sir?
Ryan Mesmore.
Mr. Blandau?
Mark Landau for the plaintiff.
Did you listen to and understand the rights, Mr. Mesmore?
Yes, Your Honor.
Do you intend to, first of all, do you wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
What is the total balance owed without giving me, I don't need a breakdown.
$3,126.25.
All right. Do you agree that you owe that amount, Mr. Mesmore?
Yes, Your Honor.
When can you pay that?
I was going to propose paying $1,500 by the 18th and then the remaining balance on the 25th.
That works?
Okay. You agree to that, Mr. Landau?
Yes.
So this will go down as a consent judgment, sir. So in the consent judgment, it's going to provide that you owe 3126.25 and that the writ date will be July 18th. But if you pay $1,500 writ date by July the 18th, the writ date will be extended until July 25th. So as long as you pay $1,500 by the 18th, you can pay the remaining balance of $1,626.25 by the 25th, and you can stay in the property. Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal this. Do you understand that?
Yes, sir.
All right. Do you have then does he have your permission to sign your name to this proposed consent judgment?
Yes, he does.
Any questions at all, Mr. Mesmore?
No, Your Honor.
Okay, I wish you well, sir. Good luck to you. Thank you very much.
Thank you.
South Point versus James Smith, 250-2529. Mr. Smith here, Jen?
No, Your Honor.
All right, so this you paid for a second mailing here, default judgment. You can go ahead and proceed.
We're seeing the entry of a default judgment of possession for non-payment of rent. The rent owing is $1805.78. We're seeking 150, but I'm going to change that to 140 in court costs for 2 months. Total is going to be 1940.
You said 140 for court costs. You mean for late fees?
Oh, yes. I'm sorry. Late fees.
Okay, and then what are the court costs?
179 in court costs. So the total is going to be $2,124.78.
All right, defendant failed to appear. Default judgment will enter. Writ date will be July the 17th of 2025. The amount to be paid to save it is $2,124.78. All right, Riverside Townhomes Riverside Townhomes versus Tamia Palmer and Jason Johnson. Tamia Palmer and Jason Johnson, 2502530. Are either one of them here, John? Doesn't appear so. You can go ahead and proceed with your default.
We're seeing entry of default judgment of possession for non-payment of rent. The rent owing is $2,879.99. $50 late charge. Subtotal is $29.29.99. Court costs are $179. Total is $3,108.99.
Defendants failed to appear. Default judgment winner. Writ date will be July the 17th. The amount to be paid to save it is $3,108.99. Riverside Townhomes versus Brendan Adams and Cheyenne Adams. File number 2502531. Ms. Adams, your name?
Brendan Adams.
Ms. Adams, your name?
Cheyenne Adams.
Okay, keep those, keep that right on here, please. Mr. Landau, your appearance?
Mark Landau for the plaintiff.
Do you listen to and understand the rights, Mr. Adams?
Yes, sir.
Did you, Ms. Adams?
Yes.
Do either one of you wish to speak to a lawyer, Mr. Adams?
No, sir.
Ma'am?
No.
Do either one of you or both of you intend to apply for funding?
No, we tried to, but we got denied.
Sir, you gotta take that phone out of
It's
here.
got to leave the building. You have to take the phone out of the building, sir.
Sir, phone's gotta leave.
All right. You're not applying for funding. You don't want a lawyer. Mr. Landau, just give me the balance due and owing.
$1,825.01.
Do you agree that you owe that amount, Mr. Adams?
I thought I said $1,600 on my end, but I guess, sir.
It was $1,646.01 on the ledger. They have not yet added the court costs into the ledger.
Oh.
So adding the 179 court costs brings it up to $1,825.01.
Now, with that explanation, do you agree to that amount, Mr. Adams?
Yes. Yes, sir.
Adams?
Yes.
Are the two of you going to be able to pay that by the 17th, Mr. Adams?
Yeah. So this Wednesday coming up in 2 days, I can put $650 or $700 down immediately, and then next Wednesday I can put another $600 to $500 down.
How much more down?
Another 600. Probably the next 2 weeks I can put about $600 to $700 down.
How about this? We set a writ date of July the 17th. If defendants pay $1,300 by July 17th, writ date extended until the 24th. Could you pay the balance by then?
Yes.
I'll make it the 25th. That's a Friday. So can you do that, Mr. Adams?
Yeah. Can you say that date one more time, sir?
Sure. You said you could pay $650 or $700 in a couple of days, and then I thought you said $650 more by next Wednesday. So
that'd be great timing. That'd be perfect. That's all I need.
So I'm giving you until a week from Thursday to pay $1,300.
Yep.
And you can do that?
Yes, sir.
And then the balance by July 25th. Do you understand that?
Yes, sir.
If you miss either one of those payments, you have to vacate. If you don't, you'll be evicted. Do you understand that, sir?
Yes, sir.
Understand that, ma'am?
Yes.
Does Mr. Landau have your permission to sign your name to the proposed consent judgment, Mr. Adams?
Yes, sir.
Ms. Adams?
Yes.
All right, Ms. Adams, you look sad. Everything's going to work out here. Relax.
Okay.
Okay?
Mm-hmm.
What are you two married?
You married us.
I married you.
Yeah, you did. Last summer.
I got 1,000% batting average. Nobody's been divorced that I've ever married. And I married about 300. And if you believe that, I'm a descendant of George Washington's too. You know what I mean? So good luck to you kids. I wish you well. Keep smiling. Good luck. Wish you well. Thank you. All right. Is that it? Is that it for you?
That's all I got.
Have a good day, Mr. Landau. Whatever happened, what's that one young man that's showing up for you? Begins with M?
Max Mudar.
Yeah, he does a nice job on these.
Oh, thank you, Judge. I will let him know. He
really does. He really
he's a
does.
great associate.
Good. Take care of yourself.
You too.
Ayler, Charles Ayler. Charles Bryant Ayler. You can come up to the podium, 25M72407.
Good morning, Your Honor. Attorney Corey Westmoreland.
Trooper, you can come on up. Sir, your name?
Charles Ayler.
All right, so he is charged with felonious assault. Let me just double check this, please. Just want to make sure everything's in order. He is charged with 2 counts of, first of all, felonious assault, a 4-year, and then felony firearm, 2-year. Your name, Trooper?
Trooper Alfafaji.
Good morning to you.
Good morning.
What does he want to do for purposes of arraignment?
Yes, Your Honor. At this time, we are prepared to waive a formal reading of my client's stance.
I'm going to advise you of your rights, Mr. Ayler. First of all, do you still live on Roland Street?
Yes, sir.
You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to a lawyer not only today, but at all subsequent court proceedings. If you cannot afford a lawyer going forward, you have to fill out a petition for one, and I will appoint you one. You have the right to be represented by a lawyer if you ever submit to questioning with law enforcement officials as well. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. At that probable cause conference, your lawyer will discuss this with the prosecutor, and you have the right to a preliminary examination within 7 days thereafter. At the preliminary exam, as to each one of these counts, the people have to show the crimes were committed and that you were the one who probably committed the crimes. If they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. If they fail to prove that as to any one count, then that count would be dismissed. If they fail to prove it as to both counts would be dismissed and you'd be discharged. Do you understand that?
Yes, sir.
Probable cause conference, July 15th. That's a week from Tuesday at 9:45 in the morning. Preliminary exam will be July the 22nd at 11 o'clock in the morning. Those are both in front of Judge Hess. Bond.
Yes, Your Honor. I would like to know that Mr. Ayler is currently residing in Detroit. He is a father of 3. He is gainfully employed at Chrysler, where he's been working there for roughly 11 years. He's not currently on probation or parole. Has no other pending matters at this time, and I don't believe he has any prior criminal history. After speaking with Mr. Ayler at length, he did assure me he would be appearing at all future court dates and understands the importance of doing so. So I just asked that all that be taken into account.
Can you tell me a little bit about this case? Do you know anything?
The defendant here was accused of pointing a firearm at another driver.
So this was a road rage incident?
Yes.
Okay. Do you know if he has any prior convictions?
I haven't looked at his
Okay, fair enough.
history.
Do you, has he already been printed? Did you print him yet?
No.
Okay. What kind of bond are you asking for here?
Whatever the court recommends us.
How much do you make at Chrysler?
Per hour.
Yes, sir.
32.
Okay. And do you have any criminal convictions?
No.
If I may add, I'm actually getting married to my fiance this Saturday.
Well, congratulations. I hope you have at least $1,500 to post, do you?
Yes.
Yes? All right. 15,000, 10% will be your bond. Don't make this worse by not showing up.
No, sir.
You do that, you're gonna end up losing that job at Chrysler and you're gonna make somebody really happy because I might go work there for $32 the way things are going here. You have to go to the MSP right now, after you post your bond, Taylor Post, to get your fingerprints and photographs taken. Do you understand that?
Your Honor, I did that at Warren, what city? Woodhaven.
Is that true?
He was at
I've
the
been
police
there.
department over the weekend.
Were you at Woodhaven?
I've been there since, 4th of July.
I dropped him off.
At the Woodhaven PD?
Yes.
Well, I'm gonna order it and I'm gonna ask you to go down the hall. My judicial clerk's not on here right now. She's got a million things going and we don't have criminal for the most part today. Just double check with her. It should show up if they printed. And if the records show that you printed, then you don't have to go, okay? Just give me 1 second. Again, I want you to understand, I'm ordering you to get fingerprinted and photographed only if not done, all right? By 1 p.m. today. So 15,000, 10%, you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No contact with the victim, Ahmad Al-Kabachi.
Yes, sir.
No contact with prosecution witnesses. You cannot write him, phone him, see him, text him, email him, or any prosecution witnesses. You can have your lawyer get a hold of prosecution witnesses, but you cannot. You cannot possess firearms. You cannot possess dangerous weapons. You have to go over to MSP Taylor to get fingerprinted and photographed by 1 today. If the lien printout doesn't indicate you've already been printed, and you have to post $1,500. I should, listen, this is serious enough where I should order a GPS tether, okay? If I order a GPS tether, you're gonna be sitting in there till Sunday. What day did you say you're gonna get married? All right, so I'm not gonna do that.
Thank you, John.
But don't play with us here. You understand? You show up. You got it? Okay. Fair enough. That's what we're gonna do. Thank you very much. Thanks, Trooper. Thanks. Good luck, sir. And by the way, you're gonna be in front of Judge Hudson, July 15th. Thank you. Williamsburg Square versus Stephen Roland, 2501959. Mr. Roland, your name, sir?
Stephen Roland.
Okay, can you do me a favor and stay right there? I'm getting a good connection. Don't keep walking around. Good morning, Ms. Austin, your appearance.
Good morning, Your Honor. Rebecca Austin for plaintiff.
What are we doing on this case? Have we heard anything? Did you get your funding, sir?
I was denied.
Okay, so you understand I'm going to give her a judgment then, right?
Yes, sir.
Ms. Austin, why don't you give me a breakdown, please?
Yes, Your Honor. Past due rent is $4,818 and 54 cents. There are 4 late fees of $70 each for $280, so that subtotals $4,818 and 54 cents. I feel like I screwed that up. Rent is $45.38.54. Late fees of $280. Total $48.18.54. I'm sorry.
Hang on a second. Slow down.
Yeah, I'm sorry.
That's all right. What is the past due rent alone?
$45.38.54.
$45.38.54. Okay, and then you have $280 in late fees. What about court costs?
$176.54 for a total $4,995.08.
Do you agree that you owe that amount, Mr. Roland?
Yes, sir.
Can you pay that by the 17th?
Not by the 17th. So today's 7th, 8th. By the 22nd, I could probably have it all paid up.
What can you pay by the 17th?
Probably 1,500, maybe $2,000.
Here's what I'm going to do. I'll give you a judgment. $49.95. This is after hearing. If defendant pays $1,700 by July the 18th, writ date extended until the 24th, you said?
22nd, yeah.
I'll extend it to the 24th nonetheless, okay?
Thank you.
But you have to pay $1,700 by July 18th. If you don't, you have to vacate. If you don't do either one of those things, you're going to be evicted. And then you have to pay the rest by the 24th of July, which would mean you'd have to pay $32.95.08 after you paid the first $1,700. You agree and understand all of that? I mean, I'm sorry. Let me repeat that. Do you understand that?
Yes, sir.
All right. Do you have any questions?
No, sir. Thank you.
Anything else, Ms. Austin?
No, Your Honor.
All right, Mr. Roland, I wish you well. Just make sure you stay on that payment plan, okay?
Yes, sir. Thank you.
Good luck to you. Thank you. Tanglewood versus Brittany Austin White. I don't know if she's here. 2502138.
Good morning, Your Honor.
Yes.
Rebecca Austin for plaintiff.
Good morning, Your Honor. Alexa Metner on behalf of Miss Austin White.
Ms. Austin White, your name?
Brittany Austin White.
Bringing in the big guns on this case, I can see, Ms. Metner. What are we doing on this?
Unfortunately, I was out last week on vacation. I did email. I just learned that Miss Austin was here for Freeman's office, so I sent her the proposal. I'm not sure if we can speak real quick before we go on the record, but we should be able to work this out.
Did she hear from the funding agency?
Miss White, did you, or Miss
Yes,
Austin?
I did. I did hear from the funding agency. They denied me.
Okay, good enough. Give me the balance. Here's what I'll do. I'm going to put this file aside. Is this your last one, Ms. Austin, or do you have others?
I have a Hampton docket, Your Honor, first hearings.
All right, let's do this. I'm going to put this file aside. Ms. Austin White, don't go anywhere. I'm going to do the Hamptons, and then I'm going to come back to, then I'll let you two go on there and discuss the Austin White matter, you and Ms. Metner, okay?
Okay.
Thanks. Don't go anywhere, Ms. Austin White. Hamptons versus Christopher Roberts, 2502533. Austin Roberts. Christopher Roberts. Do I have him here, Jennifer?
No, Your Honor. Defendant has not appeared.
You can go ahead. You paid for a second mailing, default judgment. Go ahead.
Your Honor, I'd request a possession-only default judgment. Past due rent is $2,570. There's two $70 late fees for $140 total. Subtotals $27.10. Court costs of $176.54. Total judgment would be $2,886.54. I request a writ date of July 17th.
Defendant failed to appear. Writ date will be July the 17th. Defendant's in default. Default judgment's entered. The amount to be paid to save is $2,886.54 by July 17th. Hamptons versus Caitlin Rendan, 2502534. Is Caitlin Rendan here? I don't see her. You can go ahead and proceed with your default judgment.
Your Honor, request a possession-only default judgment. Rent to retain is $1,229.54. There's one $70 late fee for a subtotal $1,299.54. Court cost of $176.54. Total judgment $1,476.08. And I would request a writ date of July 17th.
All right. So it's 1476608.
1476608, yes, Your Honor.
Defendant failed to appear. The relief request will be granted. That is the default judgment of possession in favor of plaintiff and against defendant. The writ date in this case will be the 17th of July. 1476608 is the amount to be paid to save it from the issuance of the writ. Hamptons versus Alonzo, Trent, and Lagia McCain, 2502535.
They are present.
Okay. Mr. Trent, your name, sir?
Alonzo Trent.
Good morning.
Good morning.
Your appearance, Ms. Austin?
Rebecca Austin for plaintiff, Your Honor.
Is Lagia McCain here?
She should be.
Where is she?
I'm not sure if her mic muted or something. I'm about to text her. Because she was saying she was waiting when I was waiting.
All right. Well, she's not here, so I'm going to have to default her. Mr. Trent, did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
Do you intend to apply for funding?
I do.
Judge, Miss McCain is in the courtroom. She was stuck in the breakout room.
I'm sorry. Ms. McCain, your name?
Lagia.
Last name, please.
McCain.
Mr. Trent?
Yes, sir.
You said you listened to and understood the rights, correct?
Yes, sir.
Did you, Ms. McCain?
Yes, sir.
Do you wish to speak to a lawyer? I didn't catch your answer there, Mr. Trent.
No, sir.
Do you, Ms. McCain?
No, sir.
Do either one of you or both of you intend to apply for funding? Mr. Trent?
I do.
I'm sorry?
I said I do.
You're going to apply?
Yes, sir.
Okay. Give me the total balance owed, Ms. Austin.
Inclusive of court costs, Your Honor, $2,796.86.
So I'm going to adjourn this to July 21, okay?
That's cool.
That's cool?
Yes, sir.
Is that what you said?
If it's paid by July 21, do I still have to show up?
Just make sure you do so there's no mistakes. If you pay it the next 2 or 3 or 4 or 5 days, I should say, we'll sign the order and you'll get the order of dismissal before then. Otherwise, I just make sure you show up just to make sure there's no mistakes. July 21 at what time, Jen?
9:30.
9:30. Is that cool, Mr. Trent?
Yes, sir.
All right, good enough. We'll make it July 21 at 9:30. We'll see you back here, Ms. McCain. Do you have any questions, ma'am?
No, sir.
Now, listen, if you're applying for funding, you have to submit an application to them and provide us with proof that you've done so within 5 days. Do you understand that, sir?
I do. What was the total amount one more time?
2796.86.
All right, 20.
So, ma'am, I want you to understand that too. If you or Mr. Trent or both of you are applying for funding, you have to submit proof of that to the court within 5 days. Do you understand that, ma'am?
Yes, I understand. You said 2796?
I think so.
Yep.
86. 2796.86.
Okay.
You understand what I've said though, Ms. McCain?
Yes, sir. It'll be underneath my name. I'll bring it up to the courts for proof.
Okay, good enough. You have to get it here within 5 days. Anything else? Mr. Trent, any questions?
No, sir.
Ms. McCain, any questions?
No, sir.
She looks like Rachel McRipley. You know that? You look like one of the MIDC lawyers in here. I'm serious. Have a good day. Good luck.
You too.
You too.
All right, Hamptons versus Marilyn Kirkman, Donovan Kirkman, and Corey Kirkman. 2502536. Are they here, Jen?
I
Yes.
have Marilyn Kirkman here.
Okay, I don't see her.
Miss Kirkman, your screen is very dark. Is there a light that you might be able to get
yeah.
near?
Yeah, you got to turn on a light or something.
Okay, I'm sorry.
That's all right.
Is that better?
Not much, but look, can you turn on more of a light? You got more light in there?
How about this?
That's better if you just have a seat now.
Okay.
All right, and you just hold that device right there. We're good. Your name, please?
Marilyn Hamilton Kirkman.
Ms. Austin?
Good morning, Your Honor. Rebecca Austin for plaintiff.
Is either Corey or Donovan here, ma'am? Ms. Kirkman?
No, Donovan had an appointment with the doctor's office, and my husband, he couldn't make it due to work.
All right. Did you listen to and understand the rights?
Yes, I did.
Do you wish to speak to a lawyer?
No, that won't be necessary.
Do you intend to apply for funding?
I did.
Have you heard back?
I was denied.
All right. So tell me the total balance owed, Ms. Austin.
$1,687.32.
Do you agree that you owe that amount, ma'am?
I thought as of Friday it was 1505.
I think she's probably not adding in. You're not adding in the court costs. Were the court costs in the neighborhood of $182?
Well, it's part of the court cost, the statutory attorney fee, Your Honor, and her late fee for July was now added on. It was not due as of the 4th. It's due on the 5th. So that
do you understand that, ma'am?
Okay.
So on the 4th, the late fees hadn't kicked in, and the statutory attorney fee had not been added in, and that's how there's the disparity.
Okay, so that amount again is 16 now?
1687.32. Can you pay that?
Well, what has happened is I lost my father and I had to pay for funeral expenses, being that my father didn't have life insurance, and that's
I'm really
why I
sorry
failed
about
them.
that. I'm really sorry about your loss. Can you pay this?
I can't pay it right now. It would have to be by the end of the month before I could get that up.
Can you pay some money by July 17th or 18th, which is next Thursday or Friday?
the earliest I could have something would be around the 23rd.
Ms. Austin, what's your position here?
I mean, if she can pay something by the 23rd, Your Honor, I would be fine if she could pay the balance by the end of the month.
How much can you pay by the 23rd?
Let's see, I don't have a calculator near, but I might be able to have at least 600 by then.
If the defendant pays $600 by July 24th, written date extended to July 31. Does she have, so you owe $1,687.32. If you pay $600 by July 24th of 25, that will leave you a balance of $1,087.32. Then, as long as you pay that payment, you have to pay the rest by the 31st of July. If you don't do that or don't move out or miss either one of those payment dates, I should say, you're going to be evicted if you haven't vacated. Do you understand that?
I understand.
So I think this is just as well after hearing Ms. Austin versus Marilyn Kirkman and by default versus the other two, okay?
Thank you, Your Honor.
Just give me 1 second. Ma'am, do you have any questions?
If any, if there should be any assistance by any other resource agencies, how should we do this? Will that dismiss this? Because I believe I reached out to St. Vincent de Paul and they were under the impression that was before the court costs and late fees and what have you. So they were under the impression of the 1505. So if they were willing to pay that and I had to pay the remainder, is that possible?
I thought you said they denied you. Did they not deny you?
DHS denied me, but I reached out to other resources as well. But due to the holidays.
Hang on a second. Who else did you reach out to?
St. Vincent de Paul.
Okay. I knew that's what you said. I'm not sure quite why I asked that. But the point is, did you submit an application in writing?
To DHS, I did. I did only
forget
verbally.
DHS.
Okay, no, not in writing to St. Vincent de Paul, no.
Well, Ms. Austin, I think in fairness, I'm going to let her apply for funding. Listen to me very carefully. We're not going to do a judgment today. Okay?
Okay.
You have to submit proof that you've applied for funding within 5 days. You can go to as many sources as you want. You provide proof of application for funding within 5 days. Now, if you don't have it by then, if you've heard something, well, let's not put, I'm just telling you that's going to get you an adjournment to July 21. July 21, Jennifer, at what time?
That was 9:30.
So, ma'am, you apply for funding. You provide us with proof within 5 days that you've applied for funding. You come back in here no later than July 21. I'm sorry, you come back to court on July 21 at 9:30, okay?
Okay.
But tell your other two to come, your husband, and I don't know if that's your child or what have you, but at any rate, the other two should be here too. I'll make a note. Neither of other defendants appeared.
Okay.
Okay, do you understand everything, Ms. Kirkman?
Yes, I do.
All right, do you have any questions for me?
No, that's all.
Anything else on this, Ms. Austin?
No, Your Honor.
All right, I wish you well, Ms. Kirkman. Good luck. Thank you. Hamptons versus Sharia. Slaughter, Foster, 2502537. Foster.
No, Your Honor, I've not had him check in.
Default you can take.
Your Honor, Rebecca Austin for plaintiff. I would request a possession only default judgment, rent to retain $1,083, $170 late fee for a subtotal of $1,153, court cost of $176.54, so a judgment of $1,329.54. Then request a writ date of 7/17.
Default judgments entered in favor of plaintiff and against defendant. The writ date will be on the 17th day of July. The amount to be paid to save it from the issuance of the writ is $1,329.54. Hamptons versus Daryl Travis, 25025-318. Good morning, Mr. Travis. Your name?
Good morning, Your Honor. My name is Daryl Travis.
All right, Ms. Austin.
Rebecca Austin for plaintiff, Your Honor.
Sir, did you listen to and understand the rights on the video?
Yes, Your Honor.
You wish to speak to a lawyer?
No, I do not, Your Honor.
And do you intend to apply for funding?
No, I do not.
What is the total balance owed?
$2,481.66.
Can you pay that, sir?
I'll have that in 2 weeks.
Are you sure?
Yes, Your Honor. I recently started a new job.
I just want to I don't need to hear any of that. I want to make sure.
Absolutely, I can, Your Honor.
You can have it by July 21.
Yes, sir.
Do you wish to enter into a consent judgment with Ms. Austin for that amount, $24.81? I can't read my writing, 60-some cents. And if you do that, I'm going to extend the writ date. I'll make it the 22nd of July. That's 15 days from now. Do you want to enter into a consent judgment with her?
Yes, Your Honor.
Does she have your permission to sign your name to that proposed consent judgment?
Yes, Your Honor.
You understand you have to pay $24.81.60 what, Ms. Austin? I'm sorry.
66.
66 on or before July 22nd. If you do that, you can stay. If you don't, you have to move out. If you don't pay or move out, you're going to be evicted. Do you understand that?
Yes, I understand.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You also have 10 days to appeal. Do you understand all that, sir?
Yes, I do.
Do you have any questions for me?
No, Your Honor.
All right, I wish you well. Good luck. Thank you very much. Hamptons versus Emil Springer, 2502539. How you doing there, Mr. Springer? Your name?
Good, Your Honor. I'm Emil Springer.
Good morning, Ms. Austin.
Rebecca Austin for plaintiff, Your Honor.
Sir, did you listen to and understand the rights?
Yes, ma'am. Yes, sir. I'm sorry.
Do you wish to speak to a lawyer?
No, sir.
Do you intend to apply for funding?
No, sir.
Ms. Austin, what is the total balance due?
$1,300.48, Your Honor.
Can you pay that, sir?
Is that for the month of July or the month of?
That includes the month of July, right, Ms. Austin?
It is July's rent, Your Honor. July's rent and late fee.
July's rent and the late fee.
Yes, sir. I will be able to pay that by the end of the month. I've notified the leasing office several times that the way I get paid the 15th and the last day of the month. So that's why my payments are always late like this.
All right, why don't we do this? How much can you pay, say, by the 17th?
I will say $500, sir.
Are you good with him paying $500 by that, the balance by July the 31st?
Yes, Your Honor.
So, sir, you want to enter into a consent judgment with her that indicates that you owe the plaintiff $1,300.48, and it's to be paid as follows. The writ date will be July 17th, but if you pay $500 by then, I'll extend the writ date until July 31. So if you pay $500 by the 17th, you could stay in the property, and you have to pay $800.48 in the balance, I should say, of $800.48 by July 31. If you fail to make either one of those payments, you have to move out. If you don't, you will be evicted if you haven't moved out and haven't paid. Do you understand that?
Yes, sir. Can you give me that balance one more time?
$1,300.48. $500 has to be paid 2 weeks from today. I'm sorry, by the 17th, a week from Thursday. And then the balance has to be paid by the 31st. Do you understand that?
Yes, sir.
Does she have your permission to sign your name to a proposed consent judgment setting forth those terms?
Yes, sir.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You also have 10 days to appeal this. Do you understand that, sir?
Yes, sir.
All right. Do you have any questions for me?
No, sir.
Wish you well. Good luck to you. Thank you very much.
Thank you.
Okay. Neotia Clemens, Hamptons versus Neotia Clemens, 2502540. Good morning, ma'am. Your name?
Neosha Clemens.
Ms. Austin?
Rebecca Austin for plaintiff, Your Honor.
Ma'am, did you listen to and understand the rights
Yes, I did.
Wish to speak to a lawyer?
No.
You intend to apply for funding?
No.
Ms. Austin, what's the balance?
$2,682.08.
You agree that you owe that amount, ma'am?
Yes.
Can you pay that amount?
I can't pay it right now, but I do have a couple payment plans I can do. Today I can give $600. By the 17th, I can give $1,200. And by the 30th, I should have everything paid off in completion.
You good with that?
Yes, Your Honor.
Defendant pays, let's just make it easy. If defendant pays $1,900 by July 17th, writ date extended until the 31st. Do you agree to that, ma'am?
Yes. Your Honor, may I have a question?
Sure.
Is there any way we could possibly waive one of those court fees? Just because I want to be able to pay this and not have any additional fees left over. I want to have it paid in completion.
I don't know what you mean by that. They think you owe $26.8208.
Right. Is there how much for the court fee?
$176.54, Your Honor, is the court cost.
I mean, they're entitled to those. There's not a lot I can do.
I understand. I was just asking. I mean, I figured at least ask and see.
Sure, fair enough, fair enough. So here's what we'll do. I'm going to extend the writ date. If you pay $1,900 by July 17th, then you have to pay the balance by July the 31st. And you just told me you can do that, correct?
Yes.
And does she have Ms. Austin have your permission to sign your name to this proposed consent judgment setting forth those terms?
Yes, Your Honor.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment, 10 days to appeal. Do you understand that, Ms. Clemens?
Yes.
Do you have any questions for me at all, ma'am?
No.
Okay, I wish you well. Have a great day.
Thank you. You
And
do the same.
we'll get that judgment out to you. Thank you. Hamptons
Thank you.
versus Deja Taylor, 02541. I don't see her out there. She's not out, Jen?
No, Your Honor.
Default judgment.
Your Honor, Rebecca Austin for plaintiff at request of possession only default judgment. Past due rent $1,098.46. There's $170 late fee. That subtotals $1,168.46. Court cost of $176.54. So a judgment of $1,345, and I request a writ date of July 17.
Okay, default judgment's entered. Defendant failed to appear. Relief request will be granted. Default judgment of possession in favor of plaintiff and against defendant. Writ date will be the 17th of July, 1345. The amount paid to save it from the issuance of the writ. Hamptons versus Brian Walker, 2502542. I don't see him out there. He's not out there, is he?
No, Your Honor.
Default judgment.
Your Honor, Rebecca Austin for plaintiff at request of possession only default judgment. Rents retained $1,073.46. There's $150 late fee for a subtotal of $1,123.46. Court cost of $176.54. So the total judgment's $1,300, and I'd request a writ date of 7/17.
All right, defendant failed to appear. The relief request will be granted. Default judgment of possession in favor of plaintiff against defendant. Writ date will be the 17th of July. And $1,300 is the amount to be paid to save it from the issuance of the writ. Hamptons versus Severn Marsh and Andre Marsh, 2502543. Mr. and Mrs. Marsh, I don't know why your screen's so blurred. I don't know. I mean, I can live with it. Not
The computer's off, sir. I'm sorry.
okay, that's all right. I need to be able to pick. Who's that, your kid?
We got low internet.
You got what?
Right now.
You got what?
Our internet is running slow right now. The internet is running slow.
Okay, what is your name?
Andre Marsh.
What is your name, ma'am?
Severn Marsh.
Did Ms. Austin, your appearance?
Rebecca Austin for plaintiff, Your Honor.
Did the two of you listen to and understand the rights?
Yes, sir.
Whose baby is that? That's all right. Show the baby.
I'm sorry, that's our grandbaby.
That's all right. I was around a bunch of grandbabies all week.
Sorry about that.
Wow.
Sorry about that.
You're getting old too, huh? Not that old. All right. Did the two of you, you listened to and understood the rights? Do you, either one of you or both of you wish to speak to a lawyer? Mr. Marchand?
No.
No. Do either one of you or both of you intend to apply for funding, sir?
No.
No.
Ma'am?
No.
All right. Give me the total amount owed, Ms. Austin.
$2,791.43.
Can you pay that?
We have $1,250 right now.
Okay.
And we should be able to pay the rest of it by the end of the month.
All right, I'll tell you what. If defendants pay $1,250 by July 17th, writ date extended until July 31. So that means you pay $1,250 by that date. I'm going to extend the writ date until July 31. So you have to pay $1,250 by July 17th. So if you have it now, you might as well bring it up there before somehow you spend it or what have you. And then you have until the 31st to pay the balance. Do you understand that, Mr. Marchand?
Yes.
Do you agree with those terms? You good with those terms?
Yes, sir.
Yes.
Are you Ms. Marchand?
Yes.
And does Ms. Austin have your permission to sign your name to a proposed consent judgment that incorporates those terms? In other words, indicating you have to pay $27.91.43 with $1,250 to be paid by the 17th and the balance by the 31st, with the understanding that if you miss any one of those payments, you have to vacate, and if you don't, I'm going to sign an order and you're going to be evicted. Do you understand that, sir?
Yes, sir.
Ma'am?
Can I have that balance again? I'm sorry.
Do you understand that, ma'am?
Yes, sir.
I keep saying Marchand because you got Marsh.
No,
It's Marsh. I get it.
And
I get it. I get it. Do you have any questions, Mr. Marsh?
I just need that balance again.
The balance is $27.91.43, unless you tell me you don't agree with that. Do you agree with that balance?
Yes, I agree with it.
And you do, ma'am?
yes, sir.
And again, she has your permission to sign your name to the proposed consent judgment, correct, Mr. Marsh?
Yes, sir.
Ms. Marsh?
Yes.
And you understand that you have to pay $1,250 by July 17th to get the writ date extended until the 31st. If you miss that first payment, you've got to vacate by the 17th. Do you understand that?
Okay.
Yes, sir.
Yes, sir.
All right, I wish you well. Any questions, Mr. Marsh?
No, sir.
Ms. Marsh?
No, sir. Have a good
All right,
day.
best of luck to the two of you. I wish you well. Good luck. Thank you. Hamptons versus Kalia Bowsley and Terrence Perkins, 2502544. Either one of them here, John.
No, Your Honor.
Default judgment.
Your Honor, Rebecca Austin for plaintiff at a request of possession only default judgment, rent to retain $787, $170 late fee for a subtotal of $857, court cost of $221.43, so a judgment of $1,078.43.
Wait a minute, I got to slow this down. Did you say seven? You kind of cut out. Is it 787?
787.
And then $70 in late fees for 857.
Yes.
And then court costs of
$221.43
for a total of $1,078.43. All right, and writ date will be July 17th. Defendants failed to appear. The relief requested will be granted. That is a default judgment, possession in favor of plaintiff against defendant. 107,843 will be the amount to be paid to save it from the issuance of the writ, and the writ date will be July the 17th. Are you done, Ms. Austin?
Yes, I just need to speak with Ms. Metner.
I'm going to move her to
That's
do that
right.
now.
So you go in there and talk to them on Tanglewood. I've got owner's management, and then I'm going to come to yours, Mr. Staver. What time were yours scheduled?
10 o'clock. Your Honor.
10 a.m., Your Honor.
All right, so I'm running a little late here.
No problem.
So I'll be right with you, okay? Owner's management versus Justin Spicer, 2502423. Is Austin Spicer here, Jen?
I've not had Spicer check in.
All right. Mr. Lechner, default judgment, your appearance.
Good morning, Your Honor. Attorney David Lechner,
number 67994 on behalf of Owners Management. And just to make sure the record's correct, it's Justice Spicer.
Yeah. You told me that last time, so I did make a note of that. So it's Justice Spicer, 2502423. This will be a default judgment. You can go ahead and proceed.
This is for possession only, Your Honor. This was
I see.
For cause.
So we're just do a writ date
of July 17th.
Writ date of July 17th. Defendant neglected to show. Owners Management versus Chastity Brouso, 2502469. Your appearance again.
David Lechner on behalf of Owners Management, Your Honor.
Ms. Brouso, your name, ma'am?
Chastity Brouso.
All right.
Patricia Pronick, Your Honor, on behalf of the defendant.
Oh, she contacted you before? You guys were never here for a hearing?
No, she was proactive, Your Honor.
Wow. Ma'am, did you listen to and understand the rights on the video today? Ma'am?
Yes.
Did you listen to and understand the rights on the video?
Yes.
All right. You've spoken with Ms. Prunick, correct?
Yes, I have.
Is she going to apply for funding?
This is also for...
Oh, termination. My mistake. I'm sorry. What are we going to do on this?
So Ms. Brouso does not agree with the allegations in the complaint, Your Honor, and the notice to quit. I did speak with Mr. Lochner just a few minutes ago. We're agreeing to adjourn a week so that we can continue discussing this matter.
This is a first hearing, Your Honor, so we don't have an objection to that.
I get it. July 14th, Jen, at?
10 a.m.
At 10 a.m. Okay, what are the allegations here, Mr. Lechner?
That Ms. Brouso threatened an employee of Owners Management, that she has an unapproved dog, and that she has been leaving garbage in the hallway.
Your Honor, I believe the complaint in notice to quit only mention the threats. They don't mention the dog or the trash.
I will give Ms. Prunick notice of that, and if it goes to trial, we'll amend the complaint ahead of time.
All right, we'll see everybody next week, July 14th, 10 a.m. Thank you,
Your
Will.
Honor. Do I need to appear to that?
Yes, ma'am.
Yes. Okay, I have surgery.
Right.
That's right. I have surgery on the 9th. That's going to be a problem for me. That is correct. Your Honor, could we get a different date for her? I did forget she had the
I mean, I don't want to know. I don't need to know what kind of surgery. Is it anything that's going to be debilitator to the extent that she can't appear by Zoom on the 14th?
I
don't need to know what the surgery is. I don't want to know. Ma'am, is there a reason you can't appear by Zoom next week?
I mean, I'm going to be in a neck brace and in massive pain. I have massive neck surgery on Wednesday.
All right. Okay. Let's just do this. I'm going to give you one more week. Okay. We'll adjourn it to July 21. All right. And then that should enable you to appear. July 21, Jennifer, at?
Time can be the same at 10.
At 10 a.m. Oh, what am I doing here? Jeez. Hang on. Yeah. We'll adjourn this to July 21 at 10 a.m. Okay? Good luck with everything.
Understood, Your Honor.
Thank you. We'll see everybody here that week, July 21, 2 weeks from today.
I'll file the default on the Justice Spicer today.
Thank you. Thank you. Donald Pitway versus Ronald Pitway. 2502023.
What's the podium here?
You can have a seat there, sir. What's your name?
Ronald Pitway.
Come on up, Mr. Pitway. You can have a seat at the table there, or you can stand at the podium, whichever is easier for you, Mr. Pitway. Your name, sir?
Don Pitway.
All right. So my hope is that the two of you, knowing that you only have one father, and knowing that you only have, how many sons? 2? 4. I don't care if you have 40. You only have so many sons or daughters. Would you two talk about this and resolve it?
I went over and picked up the hot tub,
Okay,
like I promised I would.
okay.
I went to the house looking for those antique pictures. He wasn't there. I can't find him. I wonder if he could tell us where they're at. I got all my property up, but like I told you, I believe that he either sold them.
He wouldn't do that if they weren't his property, that would be a theft.
Yeah, send him myself.
Can you guys go out and talk like men and resolve this instead of like the Hatfields and McCoys? Do you think you can try to do that?
I don't have a problem.
Don Jr., you're Don Jr., right? I don't want you anywhere near that conversation, okay? You understand? Yes?
Yes.
Good. All right, Don Sr., if you will, with Michigan State Spartans shirt on, you go talk to your son here, Ronald, and see what you guys can come up with to resolve this so that the family unit can somewhat stay intact and not have brothers arguing like. That's all I'll say. Take them to a room. Don Jr., why don't you stay in the courtroom? Don't go near them, please. Thank you. Marsh Creek. Which one do you have, Mr. Staver?
Good morning. I had the Tippet Family Trust.
You had the what?
Tippet Family Trust versus Paul Schmidt. It's
The folder
25.
probably just says attorney judge or ATTY on it.
I'm sorry, Jennifer? Did you say?
It should just have attorney abbreviated on the front of the folder. It's because it's not a complex.
Oh, I see. All right, DCC Properties versus Donald Kreps Jr., Veronica Kreps, and all occupants, 2502439. Okay.
Good morning, Judge Travis Payson on behalf of the plaintiff.
It may be behind that one, Judge. Sorry.
Sorry, Judge.
That's okay. Are the Kreps here?
Veronica is.
Who's Kaylee?
I believe it's Veronica's daughter. I just asked Miss Kreps to unmute.
Veronica, your name?
Hi, Veronica Kreps.
Kaylee, your name?
Kaylee Kreps.
Where's Donald?
He is currently working. I was trying to text him to get him to come into the meeting.
It's just a straight out termination of tenancy, right, counsel?
Yes, Your Honor.
Lease expired?
Yes, Your Honor.
Did you two listen to the rights, Mrs. Are you an occupant of that unit, Kaylee?
I don't know what to say.
No, I'm just asking. I'm just asking, do you live
Yeah.
there? Okay. Forget this legal jargon, right? Veronica, did you listen to and understand the rights?
Yeah, I did. I actually had spoken with David and we had worked out an agreement off, off the record.
Who's David?
Mr. I don't know how to pronounce his last name correctly. The owner of the home.
Do you wish to speak to a lawyer, Veronica?
I don't think I should, unless I don't know. I just know that him and I were texting and he said he had talked to his counsel and they had said that when we had came into court that they would talk with you, because he said he would give us 30 days to do the small repairs that were needed from the city when they did the inspection. I think it was like last week. But he said that it should be adjourned. So he said he would talk to his.
What are you trying to do here, Mr. Payson? Try to put this in perspective for me. I don't know what.
Sure, Judge. And to paint the picture, this is a first hearing on a termination case. I think that we can work out anything with them individually. The expectations from the property manager were conveyed to Ms. Krebs were that because it's the first hearing, we're going to get another date. In anticipation of that, we thought that we would talk before that second hearing and work something out.
All right, I'll just indicate Veronica appeared, as did Kaylee, who was the additional occupant. Donald failed to appear. I'm going to go ahead and adjourn this. How long do you guys want?
I think 2 or 3 weeks would be adequate, Your Honor.
You want the 20?
I'm sorry.
What's that?
Can somebody pronounce his name for me so I can say it right?
Who? Payson?
For the owner. How do I say his last name so I can pronounce it correctly?
You can just say owner. It's all right.
Owner. Okay. I don't want to like butcher his name. I'm so sorry. Okay. So for the owner, he, oh my gosh, my tongue's tied this morning. In the text, he said 30 days.
All right. You guys want to do 30 days? Is that good with you, Mr. Payson?
Absolutely, especially in the spirit of working this out.
What do you want to do? What do I have here, Jen? Give me like the first Monday in August.
August 4th.
August 4th at
8:30.
At 8:30 in the morning, okay? So you guys really work it out before then, and we'll see everybody back here then, okay?
All right, thank you, Judge.
Any questions, Ms. Kreps?
Yes, no, I guess, I don't know. So what do we do? So how do I know like what the repairs? Because I don't have the paper, because we're going to do them ourselves.
I don't know what you're talking about with repairs. Did they cause, I mean, I don't know. I have no, all I have is a termination of tenancy.
No, so we had to do because I had sent him the checks for May and June. He sent them back and I have them. So I texted him the info showing I still had them. So I have to resend those back along with with July for this month. That's due the 15th. And then the city was requiring a rental inspection. So there was a few little things that had to be done, like smoke detectors in the other bedrooms, like the 3 bedrooms that I didn't know we were supposed to have. So he told me that somebody would give me the paper or he would send it to me so I could get it done. And I said, I would do the repairs, whatever we need to have done on the paper.
I think it's best you talk to Mr. Payson about all of that, okay?
Okay.
I don't know anything about what you're talking about.
Yeah.
So you speak to him later after court today. Give him a call, all right?
Okay.
Thank you very much. Good luck. Good luck there, Kaylee. Thank you.
Thank
Marsh
you.
Creek versus Richard Jones, 2502219. Jones.
Okay. Now what do we do?
Morning, Mr. Butchart, your appearance.
Good morning, Your Honor. Brian Butchart, P66250. I appear on behalf of the plaintiff.
Where is Richard Jones? Is Richard Jones here, Jennifer?
He was, Your Honor.
Did you talk to him by chance, Mr. Butchart?
I did not. It appears that my client spoke with him between last hearing and now, and they had worked out some.
He's stuck in a breakout room, Judge. Let me get him.
Okay.
He should.
I still don't know which one Mr. Staver has. I've got, oh, wait a minute. You have Tippet?
Yes.
Okay, I'm going to take that one after this one. How's that? You only got one case. So get Mr. Jones out. Is he out yet or?
No, Your Honor. I'm going to
Let me go on to this other one here real quick. Tippet Family Trust versus Paul Schmidz. This is 2502513. Come on up to the podium, sir.
Good morning, Your Honor. Peter Staver appearing on behalf of the plaintiff.
He owes $26,000 in rent, you're saying?
Yes, Your Honor. There hasn't been, Your Honor, this is basically a Tippet Family
But you
Trust.
served for termination of tenancy.
I did, Your Honor.
Okay.
Termination of tenancy is actually what we're seeking.
Paul Schmidz. Did you listen to and understand the rights today, sir? On the video?
Judge, I was not aware he was in the courtroom, so I did not have him placed on a tablet.
All right. You have the right to a lawyer. You have the right to proper venue. You have the right to a jury trial. If you want to speak to a lawyer, you can do so. There's no application for funding involved here since they're just doing this for termination of tenancy. They're not even asking for a possession judgment, but they do have a supplemental complaint for money damages. So they're asking that I order you out of the property, and they're asking that I enter a judgment against you for $26,400.
Well,
And I'm,
that's can't be correct. This has been, Jerry was not only my landlord, he was a close friend of mine. And
hang on a second.
and-
Hang on a second.
okay,
Do you understand all the rights that I just enunciated?
did I have a right to an attorney?
Yeah, you want to speak to a lawyer?
That would be great. I've been talking to the trust, to Daryl.
Who's Daryl? Everybody's throwing around these.
Daryl's the guy from the trust that I've dealt with over the last, well, I've known Daryl for 20 years.
I don't know who Daryl is.
Your Honor, Daryl Lawson is the successor trustee of the Tippet Family Trust.
Okay.
But I've been dealing with him and Jerry, was Jerry Tippett's niece's husband.
Well, you guys.
And this has been, Jerry told me that the house was mine.
Is Jerry dead?
Jerry died. I administered his last rites in the hospital.
What do you mean? Are you a priest?
No, but I anointed him with oil. But I'm saying, there was no reason, they had an issue with wills and whatnot.
Listen.
Yes. Jerry wouldn't have told me that the house was mine if he wasn't that type of a person. And
hang on a second.
Hang
on a second.
They came
Hang
out.
on a second.
Yes.
Did he give you a quit claim deed at the time that he told you this?
No,
Did he give you a copy of?
In hospice.
Hang on.
Well, he had told me
Hang on.
prior to.
Hang on. Did he give you a copy of his will that said it was yours?
No, he
Hang
had
on.
talked to another attorney. That
Hang
was
on.
the problem. That's why it's taken 2 years
Sir.
to get to court.
Sir.
Yes. Yes.
You don't really think you're going to gain ownership of the property by telling me that a man on his deathbed told you that you
No, it
own
was
the.
prior to his deathbed.
You don't really, sir, let me
Yes.
finish my question.
Yes.
You don't really think that you're going to gain ownership of the property by coming into court and telling a judge, listen, you're going to interrupt me again, and I don't want to be interrupted again. You've interrupted me at least 2 or 3 times. Just let me finish the question. Do you really think that you can walk into a courtroom and tell a judge, listen, my buddy here told me I was going to own the property. I own the property. I don't care if it was on his deathbed, a week before, a month before, or 14 years before. That kind of thing needs to be in writing. And I don't know where you got any kind of evidence that this gentleman was transferring the property over to you, but you're really, how do I say this nicely? You got a big mountain of evidence to pull together if you're going to convince any of us that this is the case, okay? You can't just come in here and say, he told me he wanted to give me the property.
No, I understand that. I do understand that.
Well,
We
then
didn't
you're
know
living
how
in a
this was
property
gonna
that
turn
you
out.
don't own, right? Are you living in a property that you don't own?
Yes.
Okay. Did you ever pay rent on the property?
Yes.
How much?
For 15 years.
How much a month?
Depending, it was anywhere between 800 and 1100 a month.
You guys didn't have a set amount of an agreement, or in the last 2 years, let's say what it was?
It's a front and back. My mother-in-law lived in the front. We took care of her till she
I
passed.
don't need to know that.
I understand that.
I'm just asking you, how much when did Jerry die, by the way, whoever Jerry is? When did
It's been about 2 years.
Is that right, Mr. Staber?
I don't have the exact date. Yes, Judge, that's approximately right.
Were you paying rent up until he died?
Yeah, I paid it afterwards.
You did?
Yes.
Why would you have paid it afterwards if you just got done telling me that he told you owned the property?
Because nobody could tell me who owned the house, and Jerry had told me that he was leaving.
Are you $26,400 in arrears?
No.
How many dollars are you?
I haven't paid
Hang on.
anything in about the last year.
All
I had
right.
a stroke a year ago.
Okay, and how much was the rental amount?
Pardon? I'm sorry, I'm
How much?
cognitively.
Okay,
I had
I'm sorry. I'm sorry.
70% blind and
I'm sorry. I really am. Just tell me something. The last time you paid rent, what was the rental amount, monthly amount?
$1,100.
All right, so you agree that you owe $1,100 at least times 12, right?
Yes,
So you owe 13.2.
yes.
Mr. Staver, you think he owes 26.4, that he didn't pay it since Jerry died? Am I right or wrong?
You're right, Your Honor, but I could work this out at 13.2.
You could what?
I could work this out at 13,200, Judge. We would take that.
In a money judgment?
Yes.
Do you want to go into a breakout room with this gentleman and talk to him and see if you can work everything out?
Certainly willing to try, Judge.
Okay, so we're going to take you to a computer. This is their lawyer.
Okay, I'm gonna have a tough time. I had my phone, it's got my seeing AI.
Hang on a second.
Yes,
You're going to have a tough time with what?
I'm blind. I have seeing AI on my phone that
I
reads
see.
for me.
Well, he'll walk with you over to a computer,
Oh, that's
okay?
fine.
And we'll set you up with Mr. Staber, and you two see if you can resolve it. And either way, you're coming back in front of me, okay?
All right.
Thank you, Your Honor.
Thank you very much. Tanglewood versus Brittany Austin White, 2502138.
Rebecca Austin for plaintiff, Your Honor.
Alexa Metner for the defendant.
All right, what are we doing?
How does the conditional dismissal agree to? I'm typing it up right now and we'll have it filed today. So the terms that we agreed to are rent is due in the amount of $3,294.
For some reason you're cutting out. 3,000 what?
294.
Okay.
Court fees are 176.34.
Okay.
So
So that'd be 34,
54
70,
cents
34
actually. I
cents.
think it's 54 cents, Your Honor. My bad.
Okay.
So it's $3,470.54.
And what are we going to do with that?
So the defendant shall pay $1,700 on or before July 18th. And then as long as that is paid, she will have until August 1st to pay the remaining balance of $1,770.54.
Ms. Austin White, your name again?
Brittany Austin White.
Okay, is that the agreement, Ms. Austin?
Yes.
I'm asking this, Ms. Austin.
Yes, Your Honor. Too many Austins.
So ma'am, you understand and agree that you owe 3,470.54?
Yes.
You understand the case will be dismissed, but you have to pay $1,700 by July the 18th, and then you have to pay the balance due and owing, which would be $1,770.54 by August 1.
Okay.
And as long as you do that, you can stay, but keep in mind, you're still going to owe August rent after that. Do you understand that?
Yes.
If you miss any one of those payments, they're going to move to set aside the judgment.
Yes.
And I'm sorry, move to set aside the dismissal and enter a judgment, and a writ will issue ordering you out of the property. Do you understand that?
Yes.
All right. Anything, did I correctly recite everything, Ms. Metner?
Yes, Your Honor.
Ms. Austin?
Yes, Your Honor.
Do you understand everything, Ms. Austin White?
Yes.
Okay. All right. You're going to submit the order of dismissal, right, ladies?
Yeah. Okay. I'm almost done. You should get it this afternoon.
Thanks a lot. Good luck to you,
Okay.
Ms. Austin White. I wish
Okay,
you well.
thank
Thank you very much. Thanks,
Thanks, Your Honor. Have a
ladies.
great day.
You too.
Thanks, you
Thanks
too.
a lot. I know everybody's been patient here, but I got to get off this bench for about 5 minutes. I'll be back at about 11:15. Thank you. Stay seated, everybody.
On the iPhone, can I get your name, please?
Stay seated. All right. Marsh Creek. No. I know, but I got to go on to another case. Marsh Creek versus Richard Jones.
Good morning, Your Honor.
2502219.
Apologies, Judge. Good morning, Brian Butchart, P66250 for plaintiff.
Mr. Jones, start your video, state your name. Mr. Jones, you need to start your video, unmute, and state your name.
Judge, I am asking him to unmute through the program.
I'm going on to the next case. Angelique Lawrence, Marsh Creek versus Angelique Lawrence, 2502221. Ms. Lawrence, state your name.
Hi, yes, Angelique Lawrence.
Mr. Butchert?
Your Honor, this case adjourned last time. I believe Ms. Lawrence was indicating she may speak with counsel or seek counsel, and was also, I think, applying for some rental assistance.
I just need your appearance, though, Mr. Butchert. You haven't stated.
My apologies, Judge. Brian Butchart, P66250 for plaintiff.
Did you hear from the funding agency, Ms. Lawrence?
I had applied through DHS, and I have received notice from them, which was a denial. But another one I had applied for, I received an approval. They need me to pay down the balance in order to assist me.
How much are they going to give you? Have they told you?
They have not told me, but they said it will be a nice amount that will help.
A nice amount. Who's this through?
University of Michigan. They have
University of Michigan's giving out money, huh?
Well, for the employees.
Okay.
Yeah.
How much so they didn't give you any idea what they're going to give you?
I had just resubmitted the paperwork that I needed, because it had been a minute since I have received the judgment, and then
there's no judgment been entered, Jennifer.
No, I mean, I do apologize. The documentation, because they needed to receive the documentation that I was going to court for the housing, and then I did apply for other resources, and Jennifer, I did submit that. I'm sorry.
Jennifer, did we receive any proof that you submitted an application for
Yes, Your Honor, she filed the form.
But we don't have the new one on U of M, right?
I didn't pull up the actual form to see what she had listed on it. I just looked to make sure we had gotten one. Hold on one second. That was on the 24th, and she did have U of M employment fund. She does have it on her form.
All right. Well, here's what I'm going to do, counsel. I have to adjourn this one more week to July 14th. I think she's pursuing it, and I'm going to give her one more week, but you're going to have to come back in a week, and then I'm going to have to give him a judgment, ma'am. July 14th at what time?
8:30, Your Honor.
At 8?
And I have requested for counseling, and they had took my name and information, but I never heard from anybody.
I'm only telling you, well, you can call them again. You can call Lake Shore again. She'll send you the number, but you owe these guys a lot of money. What you up to now, counsel? It's got to be close to $7,000.
Judge, it's actually a little bit closer to 8. We're showing with court costs $77.15.
So
I will be able to pay that down. I have family assistance as well and everything. Everybody was just waiting for me to get that documentation from DHS and seeing, and then I just sent out for the funds for the University of Michigan.
July 14th, 8:30. Okay, we'll come back, and then they're going to end up with a judgment that day. I just want to forewarn you. And given that balance, I can't give you more than 10 days unless he agrees to it. Okay?
Okay.
We'll see you back on the 14th. Good luck. Jocelyn Niemi and Agnes Niemi. This is, again, Marsh Creek versus Jocelyn and Agnes Niemi. 252223. Your name, ma'am?
Jocelyn.
Jocelyn what?
Jocelyn Amy, sorry.
Where's Agnes?
I wasn't sure why she was listed. She's my grandmother. She doesn't live in a home. She was just my co-signer.
Well, that's why she was listed.
Yeah. Yeah, but.
All right, Mr. Butcher.
Brian Butcher, P66250 on behalf of plaintiff.
I don't know what else to do here. Did you hear from the funding agency that you made application to?
Yes, I had to send in documentation because I work at GM, but my checks are currently being garnished from my student loan. So I had to show them proof of that because of the income I was receiving. I wasn't technically qualified.
Did she provide us with proof that she'd submitted an application for funding?
I am double checking. I do not see one.
Okay, remember when I told you had to provide us with proof?
Yes, sir.
Why didn't you provide us with proof?
I wasn't sure. I've never done nothing like this before. I'm kind of nervous right now, but
well, I don't want you to be nervous, but
I know.
I made it pretty clear you have to submit the application within 5 days and provide us with proof within 5 days. What do you want to do, Mr. Butchart? I'm willing to give her another week.
Your Honor, I do have to ask the court to enter a judgment, but obviously it's within the court's discretion if you're.
Yeah, see, how much does she owe now?
Judge, we're showing inclusive of court costs, a current balance of $3,608.
Yeah, you gotta follow the direction, ma'am.
I understand.
I'm sorry. You gonna be able to pay this?
Yes, I'm able to pay it. I was just applying for rental assistance just for the extra help, but I'm able to do this on my own. Though.
When are you going to be able to pay this by?
I can pay it by August 1st when I could pay it all together. I could pay it by.
Pay me 3,600 what, counsel?
3608.
$36,3608, right?
3608. That's correct.
If defendant pays, how much can you pay by the 17th, ma'am?
The 17th. Let me double check. The day does that fall on?
That's a Friday.
It's a Thursday, Your Honor.
Thursday.
Is it?
Yeah, it's Thursday.
Yeah. I can pay.
Today's the 7th, right?
Yes.
Yeah. It's a Thursday.
I said the 18th.
Okay. Oh, yes, I could pay.
The 18th is a Friday, right?
18th's a Friday. That's correct.
Yes.
Yeah. Okay. How much can you pay by the 18th?
I could pay $1,200, $1,300.
If defendant, here's what I'm going to do. I'm going to give you a judgment after hearing. If defendant for 36,3608, you're not charging more than $70 in late fees, correct, Mr. Butchart?
That's correct.
If you pay $1,200 by July 18th, writ date extended until July 31. Okay?
Okay.
So if you miss that first payment, you have to vacate. If you don't, you're going to be evicted. If you make that first payment by the 18th, you still have to pay the balance by the 31st. You understand that?
Yes.
And I'm sorry, Judge, was that 12 or 1,300 by the 18th?
12.
12.
Okay. I wish you well, ma'am.
Thank you for working with me.
Good luck. Thanks. Marsh Creek versus Daja Thomas, 2502227.
Brian Butchart on behalf of the plaintiff. Good morning.
Daja Thomas, your name?
Deja Thomas.
Deja Thomas, I'm sorry.
No, it's okay. It's okay.
Did you hear from the funding agency?
Yes. DHS had given me $410.
All right. How much is owed on this one, Mr. Butchart, your appearance?
Brian Butchart on behalf of the plaintiff, Your Honor, inclusive of court costs, we're showing a balance of $3,862.
All right, so can you pay that? Can you pay
Could I
that?
step
ma'am?
out for a second? Thank you. Sorry about that.
Where are you?
I'm so sorry. I
Where are
had a last minute dermatologist appointment. I'm so sorry.
That's it. Can you pay that, ma'am?
Yes. So today I have paid $680 today. I have different pay dates. Sorry, I'm reading my notes right here. I can pay off someone July 11th, July 21st, August 4th,
Wait a
August
second.
18th.
Mr. Butcher, maybe I should put you two in a breakout room when we're done.
Okay.
Why don't you guys go in a breakout room? I'm going to have to go on to his other cases here, though. Oh, you don't have any other cases, do
He
you?
just has Mr. Jones that has not unmuted or started his video.
Mr. Jones, you got to call the court right now, sir. It's 734-671-0201, extension 217. I'm going to repeat that. 734-671-0201, extension 217. If we don't hear from you in the next 3 minutes, I'm going to default you. Again, 671-0201, extension 217. Southwick Square. So I'm going to let you two, Ms. Thomas and Mr. Butchart, go into a breakout room. I'm going on to another party here, and we'll go from there. Southwick versus Patricia Ojeda, 25-02438. Is she here?
She is not, Your Honor, but I believe Mr. or plaintiff's counsel had to step away to another court and should be back in a few minutes. And he's got
Granite Televalley versus Tammy Siggers, 2502532.
John Capitan, appearing on behalf of Granite Televalley.
Good morning, counsel.
Morning.
Do I have anybody here, Tammy Siggers?
No, Your Honor.
Counsel, you can go ahead and take a default.
All right, Your Honor, we request a default judgment of possession. This is a termination case. We ask that the court issue an order evicting the defendant if the defendant does not move out on or before July 17th.
Fine, thank you. Submit your order. This case was scheduled for 10:30. It's 11:33. I'll give you a writ date, enter a default judgment, writ date the 17th. Just make sure you submit that over here today, if you would, please, okay?
I will right away, Your Honor. Thank you.
Have a great day. Sorry to keep you
too.
guys waiting today. It's not going well.
Oh, no worries. I hope you have a better day.
Thanks.
All right, take care.
Are they ready on Concord? Have you chatted with Mr. Jones? Jennifer?
Judge, I've been trying to message Mr. Jones or
If he's not calling you, I'm going to pretend he didn't show up. They can't just show up like this and not answer and not call and expect that I'm going to wait all day for them. This is crazy. I mean, we've called this case before, I thought, too, did we not?
yes, Your Honor.
Man.
And I've sent him a message to please unmute. I've done the
And send him one
notifications.
more. Send him one more. You need to call and then your number immediately. If he doesn't, when the lawyer comes back, I'm giving him a default. So now who do I have? I'm waiting on lawyers, right? Is Concord and Mr. Mayers here by chance, or is it
Mr. Mayers is not here yet, but he should be
Okay.
momentarily.
All right, let me take this other case here, see what these guys are going to do here. Pitway versus Pitway, 2502023. Come on up here, guys. Mr. Pitway, if you prefer to sit there, I have no issue with it if you want to sit at the table. And Ronald Pitway.
It's all worked out. It says here.
Well, you got to tell me. Okay, I don't mean to burden you, but you guys filed lawsuits, not me. Okay.
I didn't file.
What's that?
I said I didn't file a lawsuit.
If your son was in here filing a lawsuit for you in your name without you signing it, I'm gonna have a big problem here. Did he do that? Did he sign your name? Mr. Pitway, I'm asking you a question.
I don't remember.
Well, let me just,
I imagine I did whatever.
hang on. John, come here.
Yep. It's all worked out.
Fine, good. What's your name?
John,
You gotta tell me your full name for the record. Take this over.
Donald James Pitway.
And what's your name?
Ronald Leonard Pitway.
I want you to look at the complaint on the bottom of that document. Is that your signature?
This down here, is that what he's talking?
Yeah, is that your signature? I can tell it's the son's signature by the way the son looks. Mr. Pitway, you know the great thing about doing this job is I can tell somebody who's untruthful from here to Idaho. You started filing a lawsuit, signing your father's name on these documents? Are you kidding me? Who do you think you are? Who do you think you are? Come on up here. Come on up. Yeah, you. Come on up to the podium. You, right there. Sit down, sir.
Sir, sit down, son, your son.
What's your name?
Donald James Pitway.
Junior or the second?
You can call me that. That would work.
The second.
You're the second?
Yes.
Did you file these documents?
Yes, I did.
Did you sign his name as though you were acting like him?
I signed
Yes.
my name. I signed my name.
You ever do this garbage in here again? You ever do this garbage in here again? You are out of control on this. You're the instigator in trying to cause grief between your brother and your father. I don't know what I'm gonna do on this. I really don't know what I'm gonna do.
Remember when you asked me to contact an attorney? Last time we were in here.
I didn't ask you to contact an attorney. I think I told your dad to, but I could be wrong. I don't remember.
We both went and seen an attorney.
Mr. Pitway, you could not sign a document acting as though you're your father and file it in a courthouse and expect there to be no repercussions. This is a fraud on the court. You filed an action as a fraud on the court. Listen to me.
Okay, I'll let you finish.
Thank you. I appreciate it. I don't know what I'm going to do. I don't know what the appropriate thing is for me to do. I knew you were involved in this way too much. From the very beginning, I knew you were the instigator here. I can't understand doing this kind of thing to brothers, fathers. I just don't get it. I don't understand it. I never will. I don't get it. Unless you're just being greedy in terms of getting something that's not necessarily just yours. I'm gonna tell you something. I don't know what I'm gonna do on this. I might issue a contempt charge. And you might find yourself locked up over this one. But here's the good news. I think things through. I'm not always right, but I always try to be right. But for you to do what you did in acting like his lawyer, in acting like you're him, is above the pay. It's beyond the pay. If I were you, I'd go sit in the back and I'd be quiet. And I'm going to figure out what I'm going to do. I think I know what I'm going to do, but I want to think it through. In the meantime, I'm going to deal with this complaint, if I even should, that shouldn't have been filed because your father didn't file it. What do you do for a living?
Work at Marathon is their security department.
You're a security officer? Yes?
Yes.
I cannot imagine what kind of gall it must take to do something like this.
I called legal aid.
I don't give a damn who you called.
Okay.
And I don't ever use that word. That's how upset I am right now. If you're going to tell me some lawyer told you to do this, then that lawyer is going to be disbarred.
You guys gave me the paperwork to call on that, and I followed through on it.
Hang on a second. Now you want to implicate us. We gave you the number to call because that's what we do in landlord-tenant. We don't tell people to sign people's names to legal documents. Did anybody in this building, just to be clear, tell you to sign this complaint?
No.
Knowing that you were not the Donald Pitway that's being referred to in here?
Correct.
I'm asking you a question. Did anybody in that staff, that civil department, tell you to sign this document acting as though you're your father?
No, sir.
Well, then what are you bringing up this? You gave me the number of legal aid for. You've caused a big problem here. I'm going to think this through. I think I know what I'm going to do. But I'm going to deal with them right now. So go sit in the back. Now, did you two come to a resolution? This has just been.
Yes, it was pretty simple once he was out of the area. Me and my dad worked out, I got all my stuff out. Just wants to dismiss the case.
You're going to dismiss the case? Yes?
We all got it worked out.
Yeah.
Mr. Pitway, you seem like a very nice man.
I think I am.
Well, don't let your son get in the way of you and this son.
No, he's fine.
No, he's not. No, he's not. He filed a complaint acting like it was you.
My son does all the stuff around my house.
I don't care. He doesn't file legal documents without consequences. Do you wish to move to dismiss?
Yeah, I want to.
Are you agreeing to dismiss the case?
Yeah, there's nothing.
Jennifer, prepare a dismissal order, and you agree with that?
Yes, sir.
Dismissed per agreement of the parties. You can just put it on there, Jennifer. Mr.
Yes, sir.
Pitway, I don't know. You're going to hear from me. I don't mean to sound like a tough guy, but I find this so outrageous that somebody would think they can come into a courthouse and sign a complaint and provide it and act like they are the person who owns the property, to wit, in this case, your father. Good luck. South Point Square versus Patricia Deja.
Thank you, Your Honor.
2502438. You're welcome.
Southwick Cooperative, correct, Your Honor. Creighton Gallup on behalf of Southwick.
Where's Patricia Odeja?
Your Honor, I've not had her check in.
You can go ahead and proceed with your default.
Thank you, Your Honor. Your Honor, this is date and time set for a non-payment hearing. The defendant is in arrearages. We're asking for the default judgment, the amount of $1,027.54.
Is that just rent?
Nope, $6.99 in rent, Your Honor. 3 late charges of $50, plus the statutory costs and attorney's fees of $178.54 for the total of $1,027.54.
Defendant failed to appear. Default judgment will enter. I need your judgment today, though, please, okay? Writ date will be July the 17th. The amount to be paid to save is $1,027.54. Thank you very much. And you have another one here. Concord versus Cynthia Robinson, deceased, 2502512.
Good morning again, Your Honor. Creighton Gallup, P63002 on behalf of the plaintiff, community manager, Hope Turner, who's present as well.
Is anybody living in this property?
Your Honor, I don't believe anybody's in there at this time. Unfortunately, the decedent The unit was left in a state of disrepair. The defendant was unfortunately found after some time. So we'd filed this both as a 7 and a 30-day. I don't know if there's anybody there or not. Certainly if they are, no one has been approved to be there. So there's waste being committed to the unit as there's massive remediation that still needs to be done. We're asking for a default judgment. No one from the family has come forth. There's been no estate that's been set up, nor will there likely be. So we're just asking for a possession judgment at this time.
Was this a lease to the decedent?
Yes, there was an occupancy agreement with the decedent, Your Honor. She was a member.
Turner, your name?
Hope Turner, community manager.
Who owns this property?
Miss Cynthia Robinson, the deceased. Nobody else resided in the property or was on the occupancy agreement or membership certificate with her, sir.
So what do you guys want? What is your intention here?
First and foremost, Your Honor, we want to get in there and we have to rehab the unit without getting into all the details. The defendant was not found for some time, so it's going to be extensive cleanup. There probably will not be any residual from the membership proceeds. So I think that will probably work itself out. We're only looking for possession, get it back, get it rehabbed, and then get it to a new owner at some point as quickly as possible to mitigate our damages.
Yeah, but how can I do this? Am I missing something here? I mean, how can I do this without having you set up an estate? What if somebody else has an ownership interest?
They don't. Well, Your Honor, they don't, because they would have been on the membership certificate. And since there is no estate, we can't name them as a party.
Well, wait a minute, but wait a second. What would she do if she had left this property to somebody, is all I'm asking.
Well, it wouldn't be able to, you can't transfer the property, Your Honor. This is a co-op. You can transfer the net proceeds upon the death. There are certain mechanisms in the co-op world as to trying to pass this, because it's considered personal property, because it's stock interest essentially in the corporation. So if with absent a will, it would sheet to the estate if there's no beneficiaries that come out and there's no probate that's been set up. But we did not list an estate, Your Honor, because there isn't one that exists. This is only for—
I know, but don't you have to set one up? I'm not clear on this.
No, we've never had to do that, Your Honor. This is a in rem. This is not personam on the issue. This is about the—
Okay, so let's say that there was some equity in this unit, right?
Yes.
Who gets the equity in the unit?
It would go to the member unless there was any type of paperwork.
No, but the member's deceased.
They are. However, unless there was some type of paperwork that had been authorized by the board of directors, a quasi estate planning mechanism, if there is a designated beneficiary.
Let's say I own the property and I buy it. I'm just asking you. I'm not trying to argue with you, Mr. Gallup.
Okay.
These always concern me, and I just find on landlord-tenant, people try to short circuit some of these landlord-tenant issues.
No. So
if I own that property and I die,
yep.
What happens to the proceeds?
Okay, so first what we'll do is we'll get the unit ready for sale. We'll sell it to an approved member. Any net proceeds that exist, if there are any, we would hold those for 1 year until they would sheet to the state of Michigan, unless a family, an estate, or if there was some type of small estate affidavit that maybe came in for beneficiaries to a will. I mean, there's so many different options. We're not sure what could happen.
How long has Cynthia Robinson been deceased?
It's been at least 2 or 3 months. Ms. Turner?
So Miss Robinson died June the 3rd. And if I can, Your Honor?
Sure.
There's no will. There's no trust. I spoke with Miss Robinson's 2 daughters, whom she was estranged from for many years. And I did advise them to file in the probate court. I heard from them one time. I haven't heard from them since. I told them what the what we would be doing as far as filing for, eviction. Because this is also non-payment, and nobody else resided there with her at the unit she's in now. She's been there she lived in a different unit.
You didn't sue for non-payment. You sued for.
I know, I'm just saying, but it would have been everything. There's nobody come forward with anything as far as a will or anything else. I've heard nothing else from them.
So yeah, Your Honor, just so the court is clear, and we can assure you the co-op does not keep this money. In the event there are any proceeds, we would hold it for 1 year and it was a sheet to the estate. If there are family members and they are the only beneficiaries there are mechanisms under the small estate affidavit provision that could possibly go to someplace other, but the co-op does not keep these funds. We're only entitled to any out-of-pocket expenses for damages to the unit, et cetera, as set forth in our governing documents. But if there is no beneficiary.
Here's what I'm going to do. I'm sorry. I'm going to adjourn this 2 weeks. I want you to give us the address of the last known heirs, and we're going to notify them.
I don't even know that, Your Honor. I don't even have any of that.
Well, I thought you said you had a conversation. Or you had
I did have a conversation. They called me. Oh my gosh, I don't even know if I still have enough. Now, her cousin was listed as a emergency contact. I can contact her and see if I can get an address.
I want us to contact him.
Okay.
I want us to contact him. Jennifer, you get that information. I want us to contact the emergency contact cousin, if you will. Is that the cousin of Cynthia Robinson or the cousin of 2 daughters?
No, her cousin.
What about the 2 daughters? You mentioned having contact with 2 daughters.
I talked to one of them. Nope, I talked to one. They were not listed as any emergency contact, and Miss Robinson did always tell us she did not want them in her unit for any reason. Only her cousin Brenda was.
I know. I want you to supply us with the other child's number 2.
I can do that.
So I'll just indicate we're going to adjourn this 2 weeks to July 21st. At what time, Jen?
They are on the docket at 10:45.
Now, I want cousin's phone number.
Okay.
Now, let's just say that there was some equity and they wanted to transfer this into their name. You wouldn't give them a hard time about that, would you?
We're not talking about, Judge, are you talking about the money, or are you talking about the membership interest itself? Because the membership interest, it has to be approved. They have to go through an applicant. Yeah.
But my point is that I can't imagine, unless there's some reason why Concord wouldn't approve them, right?
Well, they'd actually want to have to live there, Your Honor, as their primary residence.
I get it. We're going to get, but I'm just saying, if somebody did, unless there's some red flag, they're going to approve them. I want the cousin's phone number and any of the daughters' phone numbers that you have. Send them to Jennifer by email. And we're going to reschedule this for July 21st at 10:45. I just want to look into something on this.
Before you adjourn us, Judge, Ms. Turner, is there any immediate remediation that needs to be done in the unit because we had a deceased party there, or has there been at least minimum stuff done to at least prevent further waste in the unit?
We had to have hazmat come in. It was so bad, and it's still in terrible shape.
Okay,
that cost more than half of the equity so far.
Okay, but for our purposes during the next 2 weeks, is there anything that we need to do to get access to the unit right now? Is there any other repairs, like remediation wise, other than our normal rehab we would do after somebody leaves?
No.
Okay, all right, Your Honor, I'm sorry. I just want to make sure there was nothing.
No problem. I just want to think that through a little bit. I'll see you guys on July 21. Thank you. I'm going to do this one real quick. Tippet versus Schmidz, 2502513. And Mr. Staver, your name?
Good morning, Your Honor. Peter Staver, appearing on behalf of the plaintiff.
Mr. Schmidz, your name? Paul Schmidz. Did you two talk, and is there a resolution?
Yes, we did, Your Honor. We do have a proposed resolution.
Okay, go ahead.
Your Honor, what we've agreed to is that Mr. Schmidt will vacate the premises on or before September 1. For the month of July and the month of August, he will pay $1,100 a month for each month's rent. As to money issues, Your Honor, we have some difficulty. He believes he has receipts, etc. We've agreed to an adjournment for 2 weeks for him to produce any receipts he might have that shows rental payments he may have made. So we don't have an objection if we can agree that additional 2 weeks for him to produce any kind of payments. He's also given me a phone number where I can reach out to him, so I will talk with Mr. Schmidt. We'll see if we can't resolve the issue of that. But that, we hope that will give him adequate time to completely vacate the premises, best for both parties.
So you're gonna prepare an order, a judgment that's going to say the defendant to vacate on or before September 1. There will be a September 1 writ date.
Yep.
He's going to pay $1,100 for August and September. And is that true so far?
No, Your Honor, it'd be $1,100 for July and August. Vacate by September.
I'm sorry, for July and August. My apology.
Yep. And then, Your Honor, if we could have 2 additional week adjournment.
And then the issue of money damages. So you just prepare a possession judgment that just says on there, writ date of September 1, and on the further orders, defendant agrees to pay $1,100 for the months of July and August.
Okay.
And I'd like that to get today, please. Is that what you agreed to, sir?
What, the $1,100 today? Oh, yes, to come back and,
Wait a minute. You agree to vacate by September 1.
yes,
You agree that you're going to pay $1,100 in rent for July and August.
yes,
You understand they're asking for a substantial amount of money damages.
yes.
Hang on.
We're
Just deal with me. I know you're going to try to work it out. That's fantastic. But right now, you understand they're asking for a substantial amount of money damages,
Yes.
right?
Yes,
And you understand and agree that you have to be out by the 1st of September.
yes,
And you understand and agree that you're going to pay $1,100 for the months of July and August.
yes,
And then on the further orders, you're going to not only put that counsel, defendant agrees to pay $1,100 for July and August, semicolon, trial of money damages to be set by the court. And then we're going to set a final pretrial on this on July 21. And that will be at what time, John?
John, the 21st, we can do 10 o'clock.
At 10 a.m. 10 a.m. Do you understand that, Mr. Schmidz?
yes, can I get?
Yeah, but we're going to give you notice. Does Mr. Staver have your permission to sign your name to a possession judgment that calls for you to vacate by September 1 and further states the issue of money damages will be set for trial in the future, and you're agreeing to pay $1,100 for July and August of 25?
Yes,
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
yes, sir.
All right, Mr. Staver, have I covered everything adequately?
Yes, you have, Your Honor. Thank you.
All right, so that's what we'll do. And then hopefully you guys can talk and figure out a way to resolve this before you even come back. But if not, we'll just set it for trial in 2 weeks, okay?
Thank you,
Thank
sir.
you, Your Honor.
Best of luck, you
Appreciate
guys.
your time.
Thank you very much. Marsh Creek versus Deja Thomas, 2502227. Mr. There you are, Mr. Butchart, your appearance.
Good morning again, Your Honor. Brian Butchart on behalf of the plaintiff.
Ms. Thomas,
Hi.
I need your name again.
Oh, I apologize. Deja Thomas.
All right, did you guys resolve this?
We did, Your Honor. The rent to retain possession is $3,692. That does include $170 late fee. There's court costs in the amount of $170 for a total of $3,862. Ms. Thomas has indicated she will pay $600 on the 11th, $600 on the 21st, and the balance by the 31st of July.
The 11th, the 21st, and and balance by the 31st?
Correct.
Do you understand and agree to that, ma'am?
Yes.
So you agree that you owe $3,862?
Yes.
You understand that a judgment will enter with the understanding that you have to pay $600 by the 11th. If you do, the writ date will be extended until the 21st. If you pay that, you have until the 31st, right?
Correct.
To pay the balance, which would then consist of 2662. Do you understand that?
Yes.
All right. And you understand, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal.
Yes.
All right. Does he have your permission to sign your name to that document?
Yes.
All right. So you go ahead and sign that, counsel. I'll take that. We'll go from there. I'm not waiting for Richard Jones. I have a feeling he's playing a game. He turns his computer on and then doesn't answer or respond. So you're all set, ma'am. I wish you well. Marsh Creek versus Richard Jones, 2502219. Mr. Butchart, your name?
Brian Butchart, once again, on behalf of plaintiff.
Have we heard from Mr. Jones, Jennifer?
No, Your Honor, I've messaged him. I gave him my phone number again. I've not heard any response.
Hang on. I'm just going to go ahead and give you a judgment, counsel. Go ahead and proceed.
Thank you, Your Honor. At this time, there is rent to retain possession, the amount of $5,177, 2 late fees totaling $140, court costs the amount of $170 for a total of $5,487. Judge, I would indicate for the record, it does appear, I received an email from my client that the parties did communicate the potential for a payment arrangement. Unfortunately, though, the details are not such that I'm able to really get it into a judgment in a format that would be acceptable to the court or to me, frankly.
Writ date will be July 17th. Defendant failed to appear as far as the court is concerned. The amount to be paid to save is $54.87. I think he just turned his video on like that or logged in and didn't respond. And it's clear to me, I think, that he's just not there. So I'll let you go. You can please send over your judgments today. Thank you very much.
Always a pleasure to be in front of you.
Always a pleasure. Concord versus Lashana Warner, 2502237. Good morning, Mr. Mayers.
Morning, Your Honor. For the record, Ralph Mayers, P23815, appearing on behalf of the plaintiff.
Is Ms. Warner here? Your name, ma'am?
Lashana Warner.
All right. Did you apply for funding?
I did, but that didn't work in my favor.
Okay. Tell me how much is owed on this, Mr. Mayers.
The amount due knowing, Your Honor, for 2 months of carrying charges is $1,108. We have costs in the amount of $104.33.
And again, your late fees are $70 or less a month, right? Aren't they usually $35? So what do you have here? 1108. You have 1233. Is that the amount?
Correct, Your Honor.
Ma'am, can you pay that?
I can't pay that in full. I spoke with.
Tell me what you can pay and when.
So, if I could clear my entire balance on my next pay period on the 18th, that would be ideal for me, honestly. But if there's something specifically required, I'll do my best to meet whatever is required.
I'll give you Mr. Mayers, I'm going to give her till the 21st to pay, okay? That's a Monday, and you make sure you pay it by then, okay? So the writ date is not going to be the 17th. They're entitled to one within 10 days. I'm going to make it the 21st, which is 2 weeks from today, but you have to pay that amount in full. Do you understand that?
I do.
And that will be a judgment for plaintiff after hearing, Mr. Mayers.
I will present that today, Your Honor.
Okay, ma'am. Any questions?
No questions.
I wish you well. Make sure you get that paid, okay? Good luck.
Thank you.
You're welcome. Concord versus Mary Skelton, 2502440. Ma'am, your name? You have to unmute.
Can you hear me now, Mary Skelton?
Yes, I can. Did you listen to and understand the rights?
Yes, I did.
And your appearance, Mr. Mayers?
Ralph Mayers, Your Honor, 23815, appearing on behalf of the plaintiff, Concord.
Do you wish to speak to a lawyer, ma'am?
No.
Do you intend to apply for funding?
I only owe $168.47 as it stands right now.
Is that true, Mr. Mayers?
I have a different number, Your Honor. I could break it down if you'd like.
Tell me give me your total number right now. What's your total?
$613.67 on the carrying charges.
So that
Is that for,
is that
for July?
Yeah, well, your rent's due on the 1st, right, ma'am?
Yes, but they usually give us till the 10th to pay it. That's the
Oh,
thing.
but
I have
can't
been
do
behind
that.
because of work.
Give me your breakdown, Mr. Mr. Mayers.
Your Honor, I will. There was a notice to quit that went out for May in the amount of $893.67. That was May. June was $445 plus a 30 late charge, so a total of $475 for June. The 10th of July makes her late, so she's not late for July. It's only $445. Adding those three numbers up, it comes to $1,813.67. And I talked to the office this morning before I zoomed in. There were three payments totaling $1,200, which when we deduct them from the $1,813.67 total, we have a total due and owing, and this includes July, $613.67.
Okay, ma'am, do you agree that you owe that amount?
Yes, I do.
We have costs too, Judge, $104.33.
Okay, so plus $104.33, which brings the total to should be $718 even, right?
We match, Judge. That's perfect.
So, ma'am, when can you pay that?
Okay, well, this is the thing. I have not been working full time like I was originally hired for. That's why everything got behind. I can pay everything by the end of July. My last paycheck is going to be the 31st, and I can get everything in there by then. I'm only working about 25 hours a week right now.
Mr. Mayers?
Well, Your Honor, since we've included July in the amount, if she pays it by July 31st, I have no problem with that as the writ date.
Okay, ma'am. So he's going to give you until July 31. Now, that would be a consent judgment. You agree that you owe that amount and that you're going to pay that amount by July 31. Is that true?
Yes.
You have 3 business days since you're unrepresented by a lawyer to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes, I do.
All right. So he has your permission to sign your name to this proposed consent judgment?
Yes.
So again, the judgment will be for $718, pay by July 31. That'll be the writ date. You have to pay up or vacate by that date. If you do neither, you're going to be evicted. You understand that?
Yes, I do.
Okay, Ms. Shelton, any questions at all, ma'am?
No, sir.
I wish you well. Good luck. Mr. Mayers, I hope your golf game is better than mine has been.
It's coming along, Judge. Have a great day. Thank you.
Boy, I'll tell
Thank you.
I'm struggling right now. I can't figure out if it's age or I think it is. Good.
Join the club.
Take it easy. Good to see you. Christopher Joseph Bowinski, 24B. This is 709-335, but I also have another one that I'm going to do. Okay, this is Christopher Joseph Bowinski, 25B 715-241. All right, detective, your name? You're muted. You have to unmute. There you go, I think. Your name?
Good afternoon, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor.
So right now I'm on the OWI 3 signing on record. You can go ahead.
Your Honor, on May 19th of 2024 at approximately 7:34 p.m., Officer Bernard, Officer Paul, Officer DuBois, and myself were dispatched to 24339 Kingston Circle in Brownstown Township in reference to a vehicle that had possibly crashed into a residence at that location. While en route, dispatch advised that the vehicle was still running and the male was not responding to the female 911 caller. Upon arrival, I observed a frantic female identified as Tracy Roberts in the driveway next to a black Ford Fusion, Michigan plate EQA 1781. I did not observe any damage to the residence and noted that the vehicles parked in the driveway were not touching the residence. However, I did observe heavy front end damage to the passenger side of the vehicle. As I approached the vehicle, I noticed a white male, later identified as Christopher Joseph Mowinski, sitting in the front driver's seat of the vehicle, and that the vehicle was running. There were no other occupants in the vehicle. I further observed that Mr. Mowinski had his right hand on the gear shifter. I asked Ms. Roberts if Mr. Mowinski could be having a medical issue, and Ms. Roberts replied by stating no, that Mr. Mowinski abuses pills. I began banging on the driver's side front window of the vehicle and gave Mr. Mowinski numerous loud verbal commands to shut the vehicle off, roll down the window, and get out of the vehicle. Mr. Mowinski was not listening to my commands and only glanced in my direction and put his hand back on the gear shifter. While I was banging heavily on the window, Ms. Roberts became more frantic, screaming that she was going to break the window herself as she was afraid that Mr. Mowinski was going to attempt to leave in the vehicle. Despite heavily banging for a few more moments, he continued to refuse to obey my verbal commands and continued to grab at the gear shifter. Based on the reported possible crash and my observations of Mr. Mowinski, I determined that he posed a threat to public safety if he fled, and I requested that Officer Bernard break out the front passenger side window of the vehicle. At that time, Officer Bernard unlocked the vehicle and I was able to open the driver's side door and turn off the vehicle and secure the keys. During these interactions with Mr. Mowinski, I noted that he was disoriented, had slow and sluggish reactions, made slow, deliberate movements, and appeared to be nodding off. I also observed that his pupils were constricted and that his eyelids were droopy. Immediately after securing the keys, I told Mr. Mowinski to exit the vehicle and offered assistance, which he did not accept. While Mr. Mowinski was attempting to exit the vehicle, I noted that he was moving very slowly and that he was shaking and uncoordinated. I asked where he was coming from or where he'd been, and Mr. Mowinski only replied no. I asked if he had taken anything that day, and Mr. Mowinski did not respond. He denied that he had taken Xanax or Vicodin. At that time, Ms. Roberts stated they had just left Romulus, and Mr. Mowinski had taken 8 to 10 Soma pills, Carisoprodol, and that Mr. Mowinski gets them off the streets. I asked Mr. Mowinski to step to the rear of the vehicle and noted that he displayed a lack of coordination, that his gait was jerky, and that he had to use the vehicle to maintain his balance. I asked him to sit down on the edge of his rear bumper several times, to which he replied, okay, but did not sit down as directed. I asked him what year it was, and he appeared to have difficulty concentrating or remembering the question and failed to provide any answers. Mr. Mowinski also attempted to walk away from me at that time, but I was able to secure him and return him to his rear bumper. Once at the rear bumper again, I asked him how many somas he had consumed, and Mr. Mowinski replied 2. I asked Mr. Mowinski several questions about when he took the soma, but he failed to respond to any of those questions. Mr. Mowinski exhibited difficulty comprehending and following basic instructions, including sitting on the rear of his bumper, and exhibited serious problems with balance and coordination. As a result, I did not attempt to administer any field sobriety tests on scene. Based upon my observations, my training as a drug recognition expert, the reported crash, the location, Officer Paul's locating of 2 10-count empty Soma blister packs in the vehicle, and Mr. Mowinski's admission to consuming Soma on May 19th of 2024, I placed him under arrest for operating under the influence of drugs. I read him his chemical testing rates verbatim from the DI 177 form, and Mr. Mowinski consented to a chemical blood draw. He was subsequently transported to the Brownstown by the Brownstown Fire Department to Henry Ford Hospital in Brownstown, where a chemical draw was completed pursuant to the Michigan State Police blood kit instructions. I transported that blood kit back following its completion to the department, where I placed it in our secure outgoing mail bin and sent it to the forensic laboratory for analysis. The blood samples collected from him on May 19th of 2024 were analyzed by the MSP Forensic Science Division Toxicology Unit, and they showed that at the time of this offense, Mr. Mowinski had greater than 300 nanograms per milliliter of codeine, 13 nanograms per milliliter of morphine, and carisoprodol or Soma, and moprovimate in his system. A lean SOS CCH check for Mr. Mowinski revealed that he had 2 prior convictions for operating while intoxicated, one on February 19th of 1999 for operating while intoxicated out of the 20th District Court in Dearborn Heights, and another from August 28th of 2017 for operating while intoxicated out of the 33rd District Court in Woodhaven. The criminal history check also showed that he had 5 prior felony convictions, including one on July 16th of 2007 for felony receiving and concealing stolen property out of the 3rd Circuit Court in Wayne County. Another on 4/19 of 2019 for felony receiving, concealing stolen property, $20,000 or more, and a third on 4/19 of 2019 for felony receiving, concealing stolen property, motor vehicle. And Your Honor, I would note in addition to those convictions, he has 3 additional outstanding warrants for operating intoxicated offenses.
I see 2. Am I wrong? I see one out of Dearborn Heights. It looks like for operating while intoxicated. It says driving under the influence of alcohol. That was entered on November of 19 of 24. And then he's got this other one out of Romulus that was entered January 2 of 25.
Yeah, he has 3 warrants, Your Honor. Hang on.
He's got another warrant for contempt on other unrelated issue. But listen, I'm going to go ahead and authorize the issuance of the complaint and the warrant. I find that and by the way, you can again verify these prior convictions, February 1999 out of Dearborn Heights, 20th, and then out of this court, August 28 of 17 for operating while intoxicated. True?
Yes, Your Honor.
Based on your sworn testimony, I find that the crime, OWI 3, was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. And I'll note that you signed the complaint that was sent over. And we also have another OWI 3 warrant that was issued back in November of 24. I did the signing on record, and he didn't show up on that one. Mr. Mowinski, your name, sir?
Name,
sir?
Christopher Mowinski.
Counsel?
Attorney Corey Westmoreland, on behalf of Mr. Mowinski. At this time, Your Honor, we are prepared to waive a formal reading.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you do say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a lawyer, not only today, but at all subsequent court proceedings. If you cannot afford one, you fill out a petition for one at public expense. Also, if you ever choose to submit the questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
And I believe I called both cases, but I have 24B-709-335, and that's what this arraignment is on, with an offense date of May the 19th of 24. And I also have one from January 24 of 24 on 24B. Wait a minute. I have 25B-715-241, and I have 24B-709-335. So do you understand everything I've said so far?
Yeah.
All right. How long has the prosecutor's office had these complaints, Detective?
Your Honor, the more recent one that I just read on record, we got the final blood results from the Michigan State Police Crime Lab on June 26th. I submitted of 2025. I submitted that to the Winn County prosecutor on June 30th, and we got charges on it today. So they did not, so 10 days for the most recent one. The other case, I believe.
I know, but the blood results, they need more people. They need more toxicologists or something here. That's crazy. It's taken a year to get blood results.
Well, Your Honor, I think it has to do with issues that they were having with their confirmatory testing for benzodiazepine.
Somebody's got to figure something out. At any rate, do you understand everything I've said so far, Mr. Mowinski?
Yeah, it's snowballing on me. I understand.
It's what?
Snowballing on me. I just...
You shouldn't say another word. You have the right to remain silent. I said, And hang on. You have the right to a probable cause conference on these cases. One will be July 15 at 10:30. The other will be July 15th at 9:30.
Okay.
I don't know why we're setting for separate times, but it's gonna be the same lawyer. I'm gonna make them both at 9:30. The probable conference is July the 15th at 9:30. Preliminary exam, July the 22nd at 10:30. You have the right to a probable cause conference. At that probable cause conference, your lawyer will discuss these cases with the prosecutor. You have the right to a preliminary examination within 7 days after the probable cause conference, and you have the right to a probable cause conference within 14 days. Dates will be July 15 at 9:30, July 22 at 10:30. You'll be in front of Judge Hessen. So he's had 3, he's got 2 more, and he has 2 other warrants out of 2 other jurisdictions. This is not good.
No.
I'm Mr. Williamsky. I don't think you should say anything. I mean, you're in a heap of trouble here, my good man. I would not say a word.
Okay.
Okay, I tried to forewarn you on that at least once. This is the second time. I hope it's the last. Don't say anything against your interest here. But I'm disappointed that whatever reasons that these warrants are simply not getting authorized. And I'm not just saying it's only this case. It's like 100 out of 101 that aren't getting authorized timely. And we got a guy sitting out here that had 2 other warrants that had another drunk driving in 24, had 3 prior convictions, has a 4th offense notice, and for whatever reason, there seems to be no sense of urgency whatsoever in getting these warrants issued. Counsel, I've said enough. I'm going to listen to whatever you have to say on bond, but it's just not good.
Yes, Your Honor. I would like you to know that Mr. Mowinski is currently residing in Brownstown. As far as employment, he currently is watching his 2 grandchildren who are autistic just to help out with the family. He's not currently on probation or parole. Picked up in Brownstown where he resides. He wasn't aware of the pending charges at this time. But now that he does know, he did assure me he would be appearing at all future court dates and understands the importance of doing so. He did indicate to me he did have a prior case in front of you, and he showed up every time on time. So I would just ask that
cases out of Dearborn Heights. He didn't know about the case out of 34th. Is that what you're telling me, Mr. Mowinski?
No, I'm just getting to it right now with the guy from last night that picked me up. I'm just getting, because I moved in with my ex-wife to help out with the, it was one of my grandkids has got autistic, and Felicia Craven, that you know well, where we took over the rights of her. It's, it's.
Who do I know well?
I'm sorry?
Who do I know well? Did you say I know somebody well?
Felicia Craven, you sent her up to Winn County and chart or whatever, I don't know, but we're watching.
What are you bringing up her name for?
It's her kid. It's her kid, and we've been watching him for almost 2.5 years, and he's
Well, you
severe.
should have been in court to handle that. I don't want to hear anymore.
No. It's just, that's what I've been doing with my
Good.
time.
Good.
So,
You got 3 prior drunk drivings. You got prior felony convictions. You got 2 other drunk driving with warrants. You got these 2. That's 7. 100,000, 10% each case. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. No contact with prosecution witnesses except through your lawyer. You're not to operate a motor vehicle. I don't care if you got a valid license or not. You're not to operate a motor vehicle. You're not to be released, even if you can post, until fitted with a sober link device or a scram tether. And since these involve drugs, you're to test weekly. I just don't know if he's going to go back and forth. Some of these involved alcohol, some of these involve drunk. I'm finding that he is a serious danger to the community. Serious danger to the community. So if anybody wants to review this, I hope they'll remember me saying that. You can't have this kind of nonsense going on. Good luck. We'll see you here. Yes.
If I could request that he attend AANA, just so you're aware, The case that he was previously convicted out of, 33rd regarding, which he received the conviction on 8/28 of 2017. He had used crisaprotol, codeine, hydrocodone, oxycodone, and meprobamate. The case from January of 2024, again, codeine.
Well, I don't care if it's AA or NA, but I saw at least one of these. It looked like from the information out of Dearborn Heights that one involved alcohol. So he's going to be on both. He's going to be on either a scram tether or a sober link. And he's also, when he posts, he's going to come in here and we're going to set him up for weekly testing. So it's both. I don't care if he goes to AA or NA. It's a support group. 5 times a week, though, you have to go. No contact prosecution witnesses. You're not to operate a motor vehicle. And you do have to do those other things that I just said. Okay, you're going to test weekly, and you will be taken downtown, and you will remain there even if you can post until they fit you with a sober link device or a scram tether. And when you're released, you have to come into the probation department, and they will set.
You may be seated. Good morning, Lee. How are you? You can come out. Court does call the case of People's State of Michigan versus Jerome Burns.
Good morning, Your Honor. Great Townhouse System. And good morning, Your Honor. Assistant Public Defender, Chinazzi Carrie Kimberly, on behalf of Mr. Jerome Burns. From taking for the record.
Jerome Burns. All right. All right. Date and time set for preliminary examination. Are we ready to proceed?
People are ready, Your Honor. Defense is ready to go.
Okay. You may call your first witness.
Oh, I'm sorry, Your Honor. Before we start, I was going to approach the court about 2 things. One, just generally sequestration order. If there's anybody in here that may be a witness in this case, I'd ask them to leave the courtroom. We've had our, I'm sorry, Sam, just 1 second. There are 2 things I'm sorry about that. We've asked our witnesses to leave. The OIC is still present. And the people on our side are not going to be testifying.
Okay. So all the witnesses have been sequestered on the people's side.
Your Honor, I do not plan to call any witnesses today to testify.
All right.
And they're not going to be called later on in the case.
Well, I don't know if one could commit to that. I mean, I understand what may be the people's concern, but if they're going to be called later, they certainly could read a transcript. So, but the question would be their testimony today. Counsel approach brief. Go ahead.
One other matter, Your Honor. I've spoken to defense counsel both last time as well as today about defendant's cell phone. He had claimed there was some evidence on there that may be potentially exculpatory. I spoke to counsel. I think we've spoken to Your Honor about how we would approach that if he would like to retrieve that for him. My understanding is, I'm not sure we have a clear answer, but my understanding is that that is not something that he would want for today's purposes.
And Your Honor, I think one of our primary concerns was the cell phone in question was in my client's possession when he was arrested. Our understanding is that U of M PD later came to the jail to take the cell phone. So I'm not sure, my client did not have any conversations with anyone other than counsel about information that he would like to retrieve off of his phone. I'm sorry, I think he may have spoken to his father about information that he wanted to retrieve off of his phone. And when his father went to the jail to go and retrieve the phone, he was told that he had just missed it and that the police had just picked it up. So I'm not really sure where the information about exculpatory evidence came from. I don't have anything in my notes. I don't know if it was something that came from my office. However, it was information that our client wanted us to investigate ourselves. We're not inclined to advise him to give passwords or access to his phone to the people at this time. There may be a motion. I think I informed sister counsel that there may be a motion that we may file just to get the phone back, because our position is that if the phone is not evidence in this particular matter, then the people have, or the police have no real reason to hold on to the phone if it's not being used to investigate. If there's information that the police would like to get off the phone, I'm sure that there's a search warrant of some sort that they may be able to get. Other than that, they're really just holding on to the phone, and unless we give them access to the phone, they're not willing to give it back to us.
Go ahead.
Yeah, Your Honor, just in response to that, that's not quite the situation. So, Your Honor, specifically defendant claims there's a video on his phone of the victim consenting, which is a big deal if that is something that's truly on there. With that, our anticipation was that he would want us to retrieve that or somehow get that evidence. And we are willing to be creative in how to go about getting that limited evidence. However, so far, and as we stand here today, we have not been given permission. Now, we could absolutely go through a search warrant, and that's what we're going to do since we're not being given consent. I think there's good reason to believe there's information on there related to this case. But we wanted to present that opportunity anytime something is even close to being potentially exculpatory, whether or not I believe defendant that he has that video. His statement alone that there might be is concerning to me, and I don't want to be in a situation where it's later claimed, and I'm not saying by counsel, just later down in this case, where it's claimed that there was exculpatory information that we somehow didn't share or were in possession of. So, of course, the best way to go about is consent. I completely understand his perspective if he doesn't want to give that consent. So we can just go about it through the traditional search warrant ways.
Anything else?
Nothing else, Your Honor.
Well, correct me if I'm wrong, counsel. I think we had an in-chambers conference about this issue. And my understanding was there was going to be understanding what may be the perils of that and the fact that the people could get a search warrant, that there was going to be a decision made by the defendant prior to preliminary examination about whether or not to try to retrieve that information exculpatory. My understanding, Ms. Ackenworley, is that he does not wish that to occur. Is that correct? You may want to that mic. Ms. Ackenworley, before you say anything, you want additional time to try to talk to your client about that?
If I could, Judge.
I figured as much, only because as you were talking to him, I could see your fingers. So that probably needed to be a fuller discussion. Okay. So what I will do is I will stand in recess. You let us know when you're ready.
I sure will.
Take back.
All rise.
Thank you.
Hey, District Court for County of Washington State. Now back to session.
You may be seated. We're back on the record in the case of the People versus Burns. There's been certainly a break. Counsel and I have had a extensive bench conference regarding the issue that was raised. Secondly, it's the court's understanding, and feel free to correct me if I'm wrong, and I will ask your client to acknowledge this, that there might be some, I guess, different interpretation of what is contained on the phone. Your client may believe that it might be exculpatory for him. However, my understanding is he wishes to proceed today on this understanding that that won't be released in that fashion, and he's not consenting to release it.
That is my understanding, Your Honor. I have had an opportunity to speak with my client. I've explained to him where we are and what the people's request is. He states that although he does believe that that information is on his phone, he is not inclined to give consent or permission to the people to access his phone to take that information at this time.
And Mr. Burns, is that a correct statement, sir?
Yes, sir.
All right. And you understand that as far as this proceeding, that we will be proceeding without that information. You understand that, sir?
Yes, sir.
All right, very good.
Thank you, Your Honor. Marie Tanner for the people. People call Madison Burns and stand.
Be there. They're gonna back up as well. Thank you, folks. All right, ma'am, if you could please come forward to be sworn.
Please take a seat, raise your right hand. Solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. And see, please spell your first and last name for the record, please.
Burns, M-A-D-I-S-Y-U-R-N-S.
All right, may inquire.
Thank you, Your Honor. Hi, Madison. Thank you for your patience. I know it took a bit this morning. A few things I want to talk to you about before I start asking you questions. First one is, this is Judge Simpson. I wanted you to kind of know what we're all doing here. We're going to start with, I'm going to ask you some questions. After I'm done asking you questions, if defense counsel has questions, she'll ask you some questions, okay? If it's necessary, I'll come back up and ask some more questions, but that may or may not be necessary, okay? When you're answering questions, if you could say yes or no, as opposed to that'd be really helpful, okay?
She goes, All right, all right. Go ahead.
Okay, thank you. And you're a little soft-spoken, I am too, so we need to be really good about getting close to the microphone when we're speaking, okay? If I ask you a question that you don't understand, it makes no sense to you, please let me know that you don't understand, ask me to ask it differently. That's okay, all right? If you can't hear me, please tell me to repeat myself, okay? Same thing with defense counsel. It's perfectly fine to say that you don't understand or you can't hear or whatever the situation is, okay? If you need a break, with the court's permission, that's okay. You can raise your hand, you can ask for a break, whatever you need, okay? All right. Madison, do you know someone by the name of Jerome Burns? Okay, who's that person to you? And
Let me stop you for a second. Madison, you're gonna have to do me a favor, okay? Yeah, you're gonna have to speak louder. The thing about these microphones is they don't amplify, okay? They will pick up everything that is said, but not everybody can hear it, okay? And so when you're looking at me, I'm an old guy, so I need a voice, okay? All right, thank you.
thank you, Your Honor. Okay, and you said Mr. Burns is your husband. Do you have a child or children in common? Okay, and tell me about that. How many children?
Just one. One is 5.
5. And what's his name?
Benjamin.
Benjamin. Okay, thank you. Do you see Mr. Burns in the courtroom today? Could you describe something he's wearing? Okay. And which side of me is he seated on? Good. Sometimes that gets confusing. Your Honor, may the record reflect that the witnesses identified the defendant.
Without objection, record shall so reflect.
Thank you. So you said that your son's 5 years old. And how long have you been married to Mr. Burns?
2 to 3 years.
Okay. And were you in a relationship prior to that? Okay. I want to ask you a little bit about that relationship with Mr. Burns, your relationship with him, and then the marriage. During your marriage, could you tell me a little bit about kind of your financial situation? Okay. And where was that coming from? Why did you feel like you weren't allowed to have your own bank account? Okay, and who told you you couldn't have your own bank account? And when you say he, I'm sorry, this is really annoying, but who are you talking about? Jerome Burns. Okay, thank you. And did he tell you why you couldn't have your own bank account? Okay, no problem. So you had a joint account with him? Did you work during the marriage? Okay. So how did you and Mr. Burns have income? Okay. At some point, did you come into some money during the marriage? And what happened with that money?
Most of it he. I'm sorry, what'd you say, young lady? Did he allow you to open an account separate to put that money into? Tell me a little bit about, did he have a vehicle during the marriage? Yes. Okay. And who drove that vehicle? Did you drive that vehicle? Why not? And who stopped you from going anywhere by yourself, if anyone?
Judge, I'd like to object to this entire line of question, and I think that it's relevant to the issue and of why we're here today, and the event that occurred on May the 7th of this year.
May I respond, Your Honor?
You may.
Thank you. Your Honor, it's extremely relevant to what's going on. We're here to establish coercion. That is what this has been charged under. Notably, as the court's aware, I'm sure counsel is aware as well, coercive control is the underlying concern we have in these domestic violence type of situations, which is very much is. As the testimony develops, we'll hear more about that. These are all parts that go into showing that coercion.
Anything else, Ms. Ekin?
No, Your Honor.
Objections overruled. You may proceed.
Thank you. So I'm sorry, Madison, who, if anyone, indicated to you that you were not allowed to go anywhere by yourself in the car? Were you, if you know, were you listed on the insurance for the car? Did you want to be taken off the insurance? Did you ask to be taken off? In whose name was the car? Jerome Burns. Thank you. I want to ask you a little bit about where you lived with Mr. Burns. We don't need to go all the way back, but let's just look at like 2024, 2025. Where were you living with Mr. Burns? And were you on the lease for that apartment? Who was on the lease for that apartment? Did you ever have a cell phone? Do you own a cell phone? And did you was that cell phone always in your possession, or would someone else have that cell phone at times?
Less. So there. Told me I had to put it on the dresser, I couldn't touch it. I had to do hourly check-ins.
Okay. Can you tell the court more about hourly check-ins? What does that mean?
Makes all the base time every hour.
And who asked you to? You said he. Who asked you to do these things? Okay. And what would happen if you missed one or didn't obey that request?
So, Preston, can you describe this check-in? Was that like on a daily basis? And so this hourly check-in, you would have to call him or text him every hour. And so in the text or in the call, what were you supposed to inform him of? Okay, so I'm just trying to get, it's okay. So every hour you would have to in some way communicate to him what you were doing. How long did that last? A month or two? Okay. Just backing up to something else so that I have a full picture of this. Was that during the period in time at which you had to put the phone on the dresser and weren't allowed to look at it? That you had to shut the phones off? Do you know why that was or why you were told that, or did he tell you? You had to shut your phone off. Go ahead, Ms. Tanner.
Thank you, Your Honor. I'm sorry, Manson, you said that if you didn't obey his directive regarding the texting or calling him, I believe your testimony was that he would yell at you. Is that correct? Okay. Can you please tell the court, if you remember, what kinds of things he would yell about, or what would he explain what that would look like?
That's what I couldn't answer.
And how would that make you feel? And was Benjamin, were you home with Benjamin often? Okay.
He won't get home until around 4 with us.
Okay. And when Mr. Burns would ask you what you were doing that you didn't check in with him on an hourly basis, what would be your reaction to that? What would you do? And would that satisfy him and calm him down? And when it didn't, what would that look like? Okay. What was his tone and demeanor as he would accuse you of those things? Okay. And how did that make you feel? And I know I'm asking you to kind of think back, so if you don't remember, it's okay. What were you scared that Mr. Burns might do?
Or Preston take Perkins from me.
Okay. I want to talk about Benjamin a little bit. Does Benjamin, because you mentioned the hospital and that's what we're here to ultimately talk about. Does Benjamin have a medical condition or conditions?
Yeah, he has a muscle condition. It's like very rare. He's epilepsy.
And you said that Mr. Burns threatened to take Benjamin away. How often did he threaten to do that?
Several times.
What would lead to him threatening to take Benjamin away? What would kind of happen before that threat came?
And accusing me of doing something or talking to someone.
Okay. So he would accuse you of talking to someone. And then at some point during those accusations and the yelling, is that?
Well, a lot ever happened.
Did you believe him that he might take Benjamin away? What concerns would that cause you? I know it seems like a silly question, but what concerns would that cause you, given Benjamin's condition, if Mr. Burns took him away from you? So Benjamin's kind of medical procedures, talking to the doctors, medications potentially, was that on you, him, or was it a shared responsibility? And during this time when you took care of Benjamin and kind of coordinated his care, was that still going on when Mr. Burns would ask you to do hourly check-ins? Madison, do you have any family locally close by?
Not close. The family I have left is my brother and my dad's mom. They live in Williamsburg.
Okay. Is your father still with us?
January of this year.
January of this year? So when you and Mr. Burns were in the hospital for Benjamin in May for this incident, your father had passed away a few months prior to that.
Celebration of life. He had an attitude that he wasn't going to be taking me because my parents told him specifically over the phone.
Objection, Your Honor, hearsay.
Okay, hold on.
Sorry, you have to wait a second. Your Honor, it's not offered for the truth of the matter right now. This is to establish her mindset.
I don't think that that establishes any mindset, Judge. If it's something that she's claiming my client was upset about that someone told him, it has nothing to do with her mindset at all.
Well, it would if he then communicates that in some way to her.
I don't think that's what she's saying. She's just telling us that he was upset because.
I can ask it directly, Your Honor.
Yeah.
If it would help.
Well, okay,
That's
then
fine.
I'll sustain that at this point, but go ahead.
Thank you. Did Mr. Burns do anything or say anything to you that that he was to indicate he was upset about him not being the one to take you?
He told me that he wanted to be the one to take me and at least sit in the parking lot if he wasn't allowed in there because he wanted to be there for me. He wanted to give me a ride there because my grandma had told him that
Objection.
he wasn't allowed there and he wasn't allowed even in the parking lot.
Again, Your Honor, it's not for the truth of the matter, whether or not
I'll overrule it. I'll accept it. I mean,
it's okay. We can move on.
in accepting the answer, I'm only taking that answer to that last part as it gives context to what she's saying had occurred between her and the defendant. So go ahead.
Thank you. And And how often would you be able to see your family? The family you had left?
Maybe once a year or 2 years.
Okay. Did Mr. Burns have any, or did he express any opinions about you seeing your family?
That they had to come see me. That have time run back and forth.
To have you go see them? So I want to talk a little bit about, I might ask some more questions later, but I want to talk a little bit more about the hospital, the reason we're here today. So on May 5th, were you at Mott's Children's Hospital with Benjamin? I'm sorry, May 5th of this year, 2025. And what were you there for?
Someone's going to be getting an MG too.
And was he admitted for that procedure? Admitted to the hospital, like you had to stay there? And at that time, were you living with Mr. Burns? Okay. When did you stop living with Mr. Burns and his parents? Okay. And what led to you not living there anymore? And when you say he, do you mean Mr. Burns? And you said it was your only chance to get out. Was that because Mr. Burns wasn't home? What in your mind would happen if you try to leave when he was at home? So on April 4th, he wasn't home and you decided to leave. Can you tell the court why you decided to leave? What was it you couldn't take any more medicine? It's okay. You need a break?
Madison, you need a break? If you want to take a break, I could use one. Okay. So court standing brief.
Thank you, Your Honor. Your Honor, I apologize. The victim just went to the restroom, but she.
Okay, you may be seated, folks. Okay, we'll wait. It's on.
I'm sorry.
I just want to make sure. I don't want her having to yell.
Yeah, see. Like, you know, just like.
Yep, got it. We could wait just one moment. I want her to get back from the restroom and seated and then bring them out. Nope. Okay. Now, if you just say please. Just say please. I can be a much more pleasant person. Okay, good. We can then bring the defendant back in. We're back in the case of the People State of Michigan versus Jerome Burns. Got it. All right, the defendant is present. You may proceed, Ms. Tan.
Thank you, Your Honor. Preston, before we took a break, I asked you, you had made a comment about how you couldn't take it. That's why you left in April. And I asked you what you couldn't take anymore. You started telling us about that. Could you please tell the court? And for how long was that going on? And how long were you together, counting the dating and the marriage?
6 years.
Okay. Thank you. I don't want to go into too many details, but I do want to ask you a little bit about what the emotional abuse looked like or sounded like.
Get upset.
And did you?
I put them in the trash bag and hit them in the closet.
Were you?
Madison, when did that happen? So I'm sorry. I just trying to understand. So you had one pair of shoes?
Shoes, but they were old. One of them bought me new shoes, which were slip-on Skechers.
And just because I'm trying to get it, those were the only shoes you had at the time? Oh, well, you're right. You're actually answering my question, but I want to. Those were the only shoes that you were allowed to wear?
Yes.
So you had one pair of shoes that you could wear? Thank you. Go ahead.
Thank you. Madison, you said you hid the other shoes in the closet. Why did you hide them? And what was your concern, if any, would happen if Mr. Burns knew that you intended on keeping the other shoes? You said there were things he wouldn't let you do. We've talked about some of them, like going places by yourself, driving cars, the phone thing. Were there other things?
There's one time
Did you feel like you could hang up on him on the phone and continue your walk? And what would happen if you came rushing home in your mind? And what would, I'm sorry, I didn't hear that last part. I apologize.
So, I'm sorry. I just want to be clear. When he FaceTimed you that you had to come back, was he at home? He was at.
And you said that if you didn't obey essentially and go home and you had hung up on him and continued your walk, that he'd lash out, and then you were saying something else.
Tried to kick me out and threatened that several times. And then take Benjamin from me.
And is that why you did as he told you to?
That a yes.
Oh, sorry.
Sorry.
Okay. And Mason, you had mentioned some sexual assaults. I don't want to get into details of those because they're not charged in our jurisdiction. But can you just tell us, generally speaking, when those occurred? So you get body aches. And would this be during the time he would assault you sexually? Okay, in general. And you said you would ask him to stop. And when you say you asked him to stop, you mean you would ask him?
I do want to object because this is, again, we're talking about situations that didn't happen in this jurisdiction. I understand that people's attempt to elicit maybe, state of mind or reasonable fear, but I don't.
I'll sustain the objection.
Yeah, it's okay. We can move on. I was asking more for the timeline. I apologize. So around what, how many years ago, months ago? I'm sorry? Okay, thank you. Okay, so going back to May 5th of 2025, you're at Moss Children's Hospital with Benjamin. He's getting treatment. At some point, did Mr. Burns come to the hospital? Okay. Did he give you a reason as to why he didn't want her to come back?
He said that he just us parents that no one else needed to be in there.
Were there arrangements put in place of how and when you were going to be with Benjamin in his room and when Mr. Burns was going to be in the room? Okay. So were you in the room together with Benjamin? Okay. Before we're going to get to questions about the assault, but before the assault happened, let me ask this. I'm sorry. So, how long, if you remember, how long had you been in the hospital with Benjamin when the assault happened? Total? Okay. And did the assault happen right when you got there or a couple of days or a few days later? Okay. Leading up to the assault, did Mr. Burns engage in behavior that concerned you? Okay, can you tell the court about that, please?
Told me that he was feeling suicidal. Told me that he took half of a bottle of Tylenol.
And was that his first time talking about suicide? Okay. Can you tell the court if that's happened previously? And so in the hospital, when he was threatening suicide, did you believe that he might actually kill himself? Do you need a break? Are you doing okay? Okay, all right.
You said you're fine? Okay, just listen. It's okay. If you need a break, it's probably good for me to walk so I can get up at any point in time, okay? So you just tell me, all right? All right, go ahead, Mr.
Thank you, Your Honor. Was the threats of suicide before or after the assault? And since Benjamin was there several nights, did Mr. Burns and you stay at the hospital overnight? Okay. Where were you sleeping?
I was on the chair.
Together on the mattress? Did you want to sleep on the mattress with him? Did you end up sleeping on the mattress with him? Did you feel like you could tell him that you didn't want to sleep on the mattress? And when you say attitude, could you describe to the court what you mean by that?
Just kind of over main comments.
And what were his comments? Okay, that's okay. Thank you. Okay. I want to talk a little bit about what more immediately led to the assault, okay? At any point while you were in the hospital room with Benjamin, did Mr. Burns touch you in a way that was against your will? Okay. Can you tell the court how that started, please?
Got like touching my leg and like down that area, and of course his hand away, they just have.
Okay. And you said leg and down in that area. I know it's hard, but I need you to tell me what specifically, where on your body did he touch? Okay. Again, I know it's really hard. I need you to be very specific about where he touched you. Did he touch your genital area? Okay. What part of his body did he use? We're talking about initially to touch your genital area. Okay. Did his hand or his fingers at that point ever enter your vagina? Okay. Okay. Did you want him to touch you in your genital area? And you said you were pushing his hand away. And what happened after you pushed his hand away? Was he saying anything? What happened after he was touching your leg and your thighs, your vaginal area? What happened next? Okay. At some point, did he ask you to do anything with him? Okay, can you tell the court about that, please? Did you want to have sex with him? Did he stop asking? Did he ask one time? Okay. Can you tell the court a little bit more about that interaction, how it went? So he was asking you for sex more than one time. Was it more than 2 times? Okay. And did you have a response to that? Okay, it's okay. At some point during his asking you to have sex, did you change your mind and decide you wanted to have sex with him? Okay. Did you end up having sex? Did it occur again that he asked you to have sex?
May 7th.
Okay.
I just want to.
Okay. I want you to, as best you can, describe a little bit to the court how come you gave in. You were worried he might take your son or kill himself. Okay. And we've already talked about his threats in the past to do so. Sorry, just one moment, Your Honor.
Yes.
And did Mr. Burns, and I apologize again, I know this is difficult to talk about. Did Mr. Burns end up penetrating you? Okay. What part of his body did he use to penetrate you? Okay. I need you to please say the word. I know it's hard, and it's okay to say, I know we're in court, but with the court's permission. Okay. And when he used his penis to penetrate you, what part of your body did he penetrate? Okay. And did his penis go into your vagina past what we would call like the lifts of the vagina, the outer parts of the vagina? Okay. And is that something you wanted him to do? Was it against your will? Did Mr. Burns use any other part of his body to touch or penetrate any part of your body? We can go with touch first. Did he use any other part of his body to touch your body? Okay. Did he use any other part of his body to penetrate your body? Thank you. And we've been talking about Mott's. As far as you know, Mott's Children's Hospital, is that in the state of Michigan and Washtenaw County? Thank you. After kind of the sexual penetration and what you've described to the court, do you remember if Mr. Burns said anything to you? Would it refresh your recollection if I showed you a statement you made to police shortly thereafter? Okay. Your Honor, if I may approach before I do so, I'm showing defense counsel page 4 out of 6 of the original police report. It has been shared and discovered.
Yes, you may.
So how it's gonna work is you're just gonna read through this part. You're not gonna read it to us, just to yourself, okay? When you're done reading it, just look up around when you're done. Okay, thank you. Your Honor, may I retrieve it?
Yeah.
Madison, did that help refresh your recollection? Okay. Could you please tell the court if Mr. Burns made any statements after he penetrated you?
He said that I made you use stuff.
Thank you. I do have a couple of questions that I missed. I want to go back to. You said you moved out of his parents' residence on April 4th. Where did you go?
Stayed in a hotel for
And what was that? Was that shelter specific, or what was it a shelter for? And when you left in April, did you, again, I don't want to get into the details, but did you make complaints with other police departments reporting the previous assaults? Okay, thank you. Thank you, Your Honor. Nothing further at this point.
Cross-examination. Madison, are you good? Okay, all right. Cross-examination.
Thank you, Your Honor.
Hi, Madison. My name is Chinaza. I'm with the Public Defender's Office. I'm representing Jerome, so I have a few questions for you, okay? All right. So you indicated just now that you and Jerome had been married for about 3 years, you said? Okay. When's your anniversary? Okay. 23? Okay. And you stated that your son went into the hospital on May the 5th. Is that correct? Okay. So when Jerome came to the hospital, how did he know you were at the hospital or that your son was going in for this procedure?
by my church.
Okay, so, but you knew he was coming to the hospital, right? Okay, and you guys, you didn't go to the hospital together? Okay. And so if that was May the 5th, that means 2 days later was gonna be your anniversary of your wedding, is that right? Okay, and Jerome bought you a gift. Did he bring a gift to the hospital for your anniversary? You don't remember if he brought you an anniversary gift or any kind of gift to the hospital? Okay. You don't remember accepting a gift and telling him how much you loved the gift that he had bought for you? Okay. So when you all were at the hospital together, and you were both in the room visiting your son, is that right? And both of you stayed there for that entire week with your son, right? And when you were there, you guys, you played games together? Okay. You and Jerome talked a little bit, I assume? You're in the room together? Okay. I want to go back just a little bit. You indicated that your son had to get an NG feeding tube, right? That was the reason for the admission. What was the reason for that? Why did he need a feeding tube? He didn't have one prior to that, right? Okay.
calories throughout the day on just food.
Okay.
A few days I had him eat just as normal every day what he would eat, just to see how many calories he was getting, so they could adjust for how much he would need to once they.
Sure. And that's something that they were doing at the hospital. Okay. No, I mean the monitoring the caloric intake at the hospital. Okay. But isn't it true that part of the arguments or issues with you and Jerome is feeding of the baby?
I'm gonna check, Your Honor. I'm not sure how this is relevant to whether or not the assault happened.
Well, Your Honor, I think that it's going to go into some of the other allegations about the telephone and the excessive oversight that she alleged that my client had over her. We have a reason, or my client has provided me with some information as to what may have led to some of those things or some of those discussions.
Your Honor, I'm concerned not only that it's not relevant, because it's quite frankly, it's not. I'm also concerned that this is all going towards, defendant has multiple times threatened, talked about taking the child away by whether legal means or unlegal means, but we certainly had discussions about family court. This seems like an attempt to make this victim look like a bad mom, and it's not only not relevant, but it's highly inappropriate for this setting.
I mean, that's by no means what I'm trying to do. I'm just
And I'm
trying
not putting that on counsel. I believe that's defendant's intent.
So what would I do with what you're attempting to try to? Tell you what, I'll be able to sort it out. I'm gonna overrule the objection. I'm gonna give you a little bit of leeway.
Understand. Okay.
Thank you.
Thank you, Your Honor. So Madison, my question was just basically, I guess the bottom line is this issue with caloric intake, it was sparked by weight loss of the child, right? Okay. You know how much weight he lost? Okay. Now, do you recall some of the arguments between or some of the issues that, well, let me just ask it like this. You made some statements stating that my client would force you to put your phone on a dresser or a table of some sort, correct? Okay, and isn't the reason that he did that because he complained you were on your phone too much? Okay, he never complained to you about not feeding the child in the manner in which he was supposed to be fed? Okay, what about the allegations or issues that you guys had in regards to infidelity?
I'm gonna object, Your Honor, that assuming fact's not an evidence, so unless there's.
Well, except that it's his accusation that that Madison actually testified to peripherally, but so I'll overrule the objection. Go ahead.
Thank you, Your Honor. You stated earlier that he would always accuse you of cheating on him, right? Or talking to other guys. I think that was what you said. And isn't it true that he has confronted you about talking with other guys and cheating on him? Okay. And isn't it true that you had multiple telephones, cellular phones? Okay, you had 2 cell phones. Okay, and you talked about you having to do these check-ins and having to keep your phone on the dresser, but my client goes to work, right? He would leave the home to go to work. Okay, and you stated that you lived with his parents at their home, and they also go to work. Is that correct? Okay, and you also testified today that your son goes to school. Okay, so at times you'd be at home by yourself or my client wasn't always with you in the house. Is that right? Okay, You also talked a little bit about him not allowing you to see your family who lived in Livonia, but he never told you you couldn't go to their house, right? Okay, but your testimony today was that he said he wouldn't take you there because he didn't have the time or the money to drive you there. Okay. So what would happen if your family were to come visit?
Mother doesn't have a license and my grandma's got health problems. She doesn't get a car.
Okay, so they just wouldn't come, or he wouldn't let them come? You said that he would let them come visit.
He told me that they could.
They did not. Okay, so they did not come visit. All right. And speaking of license, that does bring me to the next question. When you first met my client, you didn't have a license, did you? You did? Okay. All right. And Jerome, he took you to go get your license back when you did get it back, right? Okay. And at one point in time, you had a white Dodge Charger. Okay. But he had purchased that car. I mean, it was your car to drive.
It was his, and he was just giving it to me.
Okay. And what about your online bank accounts? You had some online bank accounts like through Chime and other companies?
We shared one, and then I ended up going back on my Chime.
Okay. All right, so I want to go back to the hospital. When you all were in the hospital, you said you guys played Uno together. You talked. Now, when my client, you stated today, or you testified today, that he asked you for sex. Okay, and is your testimony today that you did not tell my client that you would do it one last time with him? You agreed, you told my client that you all could have sex one last time, right? Oh. And hold on. The one last time is because you knew that my client was filing for a divorce, right? You did not know that. Okay, but you had left the home and obviously did not have intentions on coming back. Okay. And after you all agreed to the one last time, isn't it true that my client asked you again whether or not this was consensual and that you were sure? Okay, but you said yes when he said that, right? Okay, and inside of this hospital, they've got call buttons next to the beds, is that right? They've got call pull cords in the restroom, is that right? They've got call pull cords in other places inside of the hospital room, right? Okay, so much so that I think you accidentally pulled one of those call cords at one point in the hospital, yeah.
About turning the light on first.
And pulled the wrong thing, okay. And my client didn't get upset with you or loud with you in the hospital, right? He did, and what did you do when he got loud with you? Okay, but when you were in the hospital, I'm assuming that doctors and nurses and orderlies or whatever the other titles I may be missing, they came in and out the room regularly, right? Okay, and there's no lock on the door inside of the hospital room, right? Okay. When did you report? You did not report this incident. You said that this happened on the 7th. Did you give us a date? I don't know if I took note of that. I apologize. You indicated on the 7th that this had occurred, but when did you talk to someone about it? On May the 10th. Okay, no, so let's just do this. When I ask you a question, just answer.
What was your statement? It was on May 10th because
But I finally had a chance to go for a walk, and I was able to help someone.
you were able to go for. Go ahead. Okay, so you're at the hospital, you went for a walk, and then that's when you told someone. You were still at Mott's at that point. All right, go ahead, Counsel.
Thank you, Anna. So based on what you're stating right now, does that mean that you never left the room? You left the room, the hospital room without Jerome, right? Yes or no? Okay, you left the room to go possibly get coffee? Yes? Okay. You left the room to possibly go to the cafeteria, is that right? Okay, so all the food that you ate that day was ordered and brought upstairs to you? Okay. How about this walk that you said you went on the 10th? Had you not gone on a walk from May the 5th all the way to the 10th, the entire time you were there? Okay. You also—
You're saying that, I just want to make sure.
That's okay.
When you're answering no to the previous question, that meant you had not prior to that point in time gone on a walk, right? Okay. Yeah, I got it.
And the entire time you were in the hospital, you had your phone on you, right? Okay, but you had your phone on you. My client didn't confiscate your phone, either of the two phones that you have. You had both of your phones, right? And you talked to people on the phone, or you texted people while you were there, right? Okay, but at some point while you were there, were you having conversations with people on your phone? You also reported, you testified today that your father's celebration of life ceremony happened while you were there, correct? Yeah, and you had someone come and pick you up, right? Okay, so how did you were able to arrange that ride with that individual without talking to them, texting them on the phone, or communicating at all? You communicated with her on the phone, okay. And there were times where you and Jerome had left the hospital together, is that right?
If the air mattress, just he wouldn't let me stay in the hospital by myself.
He wouldn't let you stay at the hospital by yourself. So you and Jerome went to go get the air mattress. He took you to La Casa as well, right? You did not go to the shelter at all during that 5-day period you were in the hospital? You don't remember my client driving you to La Casa and sitting outside for 2.5 hours while you went in there to check in? I can't hear you. Okay. How about You don't have to do check-ins with La Casa when you're staying in the shelter? You had to do check-ins with them, right? And you were required to report to them to let them know your whereabouts and your well-being and things of that nature, right? Okay, and you did that on your cell phone, right? Okay. So you went to your father's going home or celebration of life ceremony. What day was that? Okay, it was before the 10th. So, but it was after the 7th, right? Okay, so your father's going home ceremony was after the 7th, before the 10th, so maybe the 8th or the 9th, right? Okay, and you went by yourself. That's what you testified to today, right? Someone came and picked you up and they took you to the celebration of life and you were there for however long that took and then you came back. Is that correct? Okay. And there were a number of times that Jerome left the hospital without you. Is that right? Okay, so there were times where you were there by yourself. He wasn't with you the entire time you were there, right? Okay, I don't have any questions. Well, give me 1 second, Judge. I do have a few more questions for you. Now, Jerome has never done anything to your son. Is that right? Okay, he's never abused your son, assaulted your son, or anything like that, right? Okay, and when you said that he tried to, or he told you that he had taken a number of pills, what day was that? Okay, but it was sometime while you were in the hospital, right? And doctors and nurses and CNAs and other people walked into that room, right? And if you were really concerned about the pills that he took, you didn't tell anyone, you didn't report to anyone that he may have. Okay, so you didn't believe that he had done that. Okay, no further questions, Your Honor.
Any redirect?
Okay, Madison, how you doing? A few things I wanted to follow up on. So counsel asked you about essentially telling Mr. Burns that, you know, giving in, saying, I'll do it one last time. And you were saying that you agreed because you were scared. So you did it because you were scared. Can you tell us more about that, about what was going through your mind and what that fear was?
Say if I could, because he said because it was our anniversary that was the reason that we had to, because we were still married. Sure, it wasn't long.
And you asked if Mr. Burns has ever abused your son directly, Benjamin, and the answer was no. Has he ever assaulted you or done things to you in front of Benjamin? Okay. Please tell
Your Honor, I want to object to that. I think that this is still leading towards the out-of-county
Well, actually, you raised the issue. I think you've opened the door to that regarding abuse. So if a parent something is happening to a parent in front of a child, that might be considered abuse. But I think you opened the door by your question. So objections overruled, you may continue.
Thank you. Please tell the court about that abuse in front of Benjamin.
Did anything sexual? Just we had to stay home. So whenever we would do stuff like during the night, it's obviously that. And we would get frustrated and we would start crying. We were doing stuff.
Okay, and what would that frustration look like?
Frustrated by thinking calm down, test, tell me that I wasn't telling him to quit or something.
So Mr. Burns was telling you that you're not saying no?
Telling him to quit. He doesn't comprehend words. He might say a couple words, but he doesn't know like meaning.
Okay, so Mr. Burns wanted you to tell your son to quit crying. Is that what? I'm sorry, I'm not understanding. Okay. Okay, and he was frustrated that you wouldn't say that. And when Mr. Burns would have sexual contact with you, and he would sexually assault you, the times that it was against your will, was Benjamin in the room also? While you were at the hospital between May 5th and May 12th, you started kind of getting into, in response to some of counsel's questions about the times that sometimes you were able to leave the immediate hospital room. Could you tell the court more about how that happened? When were you allowed to leave? Were there conditions put on that?
Just one.
And I kind of want to, we're asked a lot of questions about when you were around other people, when you were around from Mr. Burns. And I want to kind of group them all together. Could you tell the court the best you can why during those times, if you felt comfortable telling them and disclosing about the abuse you were going through? You were in the hospital for a few days, but was it your understanding that at some point you would go home or return to the shelter, I believe, at the time? Did you have concerns about what would happen if you had reported the assaults at the hospital? Sure. With the understanding that you were going to end up having to leave the hospital, did you have concerns about what would happen if you reported to hospital staff about the assaults? You said that on May 10th, you finally did report the assault. Could you tell the court about the circumstances that came about?
I wanted to go for a walk, make the phone call, just to get like immediately.
Okay.
And then anyway, in the corner, I seen him storm out the other day for the elevator. I thrown a fit.
And what did you do, if anything, at that point? Okay. Did you go back to the room? Who did you end up reporting it to? Okay. And how come you felt like you could report it at that point? You testified that he had told you when you got to the hospital to shut your phone or phones off, but at some point you were able to turn them back on to make calls.
I think I told him that I needed to at least do check-ins. Certain people.
So he let you turn the phones back on. One moment, Your Honor, if I may. Madison, you're asked about having two cell phones. How come you had two phones?
Got another one because won't let me touch my phone. So I needed to be able to get hold of somebody in for emergency. So I had another phone stashed that way. Outside or to or something. Get to it.
Okay, thank you. Nothing further.
How long had you had the second cell phone? From, well, hang on. When you say a few weeks or months, is that from the April 4th date or from the May date? From which date? April or May?
Back to March.
Somewhere. Okay, gotcha. All right. And when you use the word, you said you had it stashed. Where did you keep that phone? Say again? In your desk? That was at the apartment. Okay, so you kept it somewhere around there. So when you talked about, as you testified, that he told you to put your phone up on was it dresser? I think it was. Was that both phones or just the one phone? That's what I was getting at. So the second phone, he did not know.
So you wouldn't make calls on any of, on that phone? Just had it in case. Pardon?
Service on it, but I wasn't able to yet, so I was trying to figure out a way to.
Say that again for me?
Try to put a service. So, I was trying to figure out how to be able to do that.
So when you say this other phone, when you're talking about putting a service on it, a plan, okay, that's what you're trying to do. So when you first got the phone, prior to you doing that with Kroger and everything, could you call from that phone? Got it. Okay. So you had to, when you had that phone, you could make a Wi-Fi call, but you couldn't make a cellular call. That makes any sense to you, but it does to me. But you think you could call from that phone as long as you had Wi-Fi access? But what you were trying to do when you were talking about putting a plan on it, you wanted cellular service. Okay, if I'm I'm probably getting way too technical, but you wanted service like everybody else's phone, or right? I mean, not you just needed a plan so you could call from any, basically, if you needed to.
I wasn't sure if I was gonna be able to follow it out. I decided to get it.
The plan, got it. Any questions based on the court's questions? Second.
I have a few, Judge.
Go ahead.
You, your son's on Social Security disability, right? Okay, and you get money monthly from the government for that? Where does that money go? Into your account? Okay, but you, okay.
Before I had my account, we had to put in his business account.
Okay, but you were receiving money. I'm gonna.
Hold
And
on.
the reason that I'm asking that, Judge, if I may, is because she just testified that she needed to get out of the house to put money on her card because she didn't have any money on her card. So her testimony is as if the only.
Right, but if you, just my understanding, hang on, my understanding of the time frame is that she doesn't have this other account of hers until after she leaves on the 4th.
I don't believe that's the case. Is you, I don't.
Go ahead.
If the court can ask.
But I don't think I had, that money at that time. I think it already ran out.
What had run out?
Per month for vitamin.
Okay, so when did that start going into an account you had?
Past year.
Okay, but before then it was placed where? Did you have access to the business account?
And I don't have any further questions.
Anything from the people? All right, Madison, you may step down. Thank you.
Your Honor, may this witness be excused?
Any objection?
Judge, I know that it won't be convenient because I'm sure that, I know the people had inquired earlier about child transportation and childcare. I would love to be able to call her as a witness, and depending on what testimony comes out later, I don't want to be unreasonable though and say, no, she can't be excused. So I don't know.
Okay, what's her scheduling like at this point? Hey, and here's the reason I'm asking. I've got a docket, as I informed counsel, that was actually supposed to start at 12. I pushed that back to 1, that portion of the docket to 1. I have to get on that docket and try to do that. So I'm going to have to take a break if that's going to work with transport, because I know that you've got to get the 3 that I have. Okay. So I'm going to so here's what time is it? Thank you. Like Alexa. Anyway, what I'm going to do is we'll reconvene at 2:20. Well, just make it 2:30.
Okay.
To continue this exam, if that will work for everybody.
I'm not sure, Your Honor, it will. If you wouldn't mind checking.
I can check with social.
Yeah.
Officers can stay.
Yeah, I don't.
They were 10 to 8.
Yeah, Your Honor.
So did I. No, go ahead.
Your Honor's energy is unmatched, I'll say. Your Honor, I would suggest an adjournment at this point. I would like some idea of what potential, I know we can't predict what the testimony may be, but in what scenario we would bring the victim back. We can do it at a different time, but at this point, I think an adjournment would be more appropriate.
Beckham, really? How many more witnesses do you have? I had 5 listed, 5 others listed, but I think you had 1 struck off that. So would I have 4 more?
So Your Honor, yes, we have a social worker and 2 officers, so 3 more.
3 more. Okay. Ms. Ackenruther, how do you feel about the adjournment? I have no
Your
idea.
Honor, we would be objecting to the adjournment. We are ready to proceed. I don't know, again, the line of questioning that may bring rise to having to call her back. But I think that if anything, we could adjourn that portion of it if need be. But I know the court obviously has to jump on this other docket, but we're here all day and ready to proceed once the court is done with the other docket.
Well, let me just say this. Part of the reason the court's in the time position that it's in is because the court was out at 9:07 ready to start. There was some delay in terms of talking with the witnesses. I'm not going to call it a delay. The prosecutor had to talk to some of the witnesses. There then arose an issue. You had to talk.
Absolutely.
And I didn't get started till whenever, trying to give leeway as best I could to the parties so that they could be prepared. Well, let's do this. There are 2 officers? Is that part of the difficulty is the timing of the officers and their?
I think the officers, we also have to check on the victim regarding childcare.
Okay, let's do this. I'm going to give transport time to go get my people for that docket. I'm going to have him taken back and then we'll figure out if we're going to proceed, but I got to start moving something at this point. Okay. So court is staying in recess.
No, I'm totally fine. Like, love it, love it, love it. Can I ask why?